Item 1.
May I please sit?
Yes.
This writ appeal has been filed with a prayer to set aside the impugned order dated 10/7/2024 passed by the Hon'Ble Single Bench in WPC number 34311 of 2022. With a prayer, the impugned letter, annexure 15 of the caption writ petition be quashed in respect of the appellant, and further be pleased to direct that the respondent to allow the appellant to get the benefit of a retirement pension, revised pension at the rate of 6,750 with a TI with effect on 1/4/2010 in accordance with the notice at Annexure 5 incurred thereon with interest over the delayed payment of pension.
Please come to the grounds of the appeal memo. You have to demonstrate before us that there is perversity in the impugned judgment.
I'll come to that.
So how you have demonstrated so in the grounds of appeal?
I'll come to
Instead of reading the prayers, first just brief us the background facts in nutshell.
Yes.
Thereafter, how the judgment is perverse, you have to demonstrate before us.
Prior to that, this writ petition has in this writ petition, writ appeal, the challenge is the judgment of WPC number 343/2011/22. Prior to that, the petition was before this Honorable Court in an earlier writ petition, that is WPC OA number 445 of 2018. That was
before the application before the state administrative tribunal, it was transferred to this court.
Here and it was disposed of.
So there was a judgment.
Yes, in this one on 13/9.
Where is that order?
The order is that in the previous writ petition, in the writ petition number 343/11 of 2022, as page number 30, annexure 1. Annexure 1 of
You
the
have not annexed that judgment to this appeal.
because it is there in the previous writ petition, that's why it has not been, but it has been quoted also in the judgment, in the input judgment, it has been quoted and it is available in the previous writ petition, that is in the writ petition of 343/11 of 2020.
How it comes to demonstrate the perversity in the judgment?
I'll come. Just the factual background has been briefly stated in the previous judgment. So that's why I want to read out that portion of the previous judgment by a single bench of this Honorable Court.
343/11 of 2022?
No. Yes, the page 30 of that previous writ petition. And the writ petition, the previous writ petition was WPC number OA 445 of 2018.
That is not on board.
The previous record
is not on that record. The record of this WPC 343/11 of 2022 is available with us.
Yes, in that
that has been quoted.
In that writ petition, it is at page 30 of that writ petition.
Page 30. Annexure 1.
Yes, Annexure 1. So,
yes,
the petitioner who was retired as a MPS male, means multi-purpose health supervisor male,
yes,
on 30th/6/1994 has filed the writ petition claiming revision of pension in view of the notice issued by the authority published in newspaper under Annexure 1. Mr. U.C. Mahapatra on counsel for the petitioner that in view of the notice issued by the authority, namely Director of Public Health Orissa, which clearly indicate that MPHS male retired prior to 31/3/2010, these are the specific date, were entitled to get 50% of the minimum of the pay band plus grade pay, that is 9,300 plus grade pay of 4,200, that is 6,750 per month with TI for full qualifying service with effect from 1/10/2010. It is contended that the petitioner was getting less pension than what has been directed to be fixed in the notice itself. Therefore, he seeks for revision of pension as such he has retired prior to exercising 2010. Thereby,
there was a cutoff date, 20 March 2017.
So I'll come to that point.
No, that's the only point in this case. How this cutoff date is arbitrary. Government fixes the cutoff date.
There is another aspect
of the purse.
There is another aspect in this case. In the second order of the Honorable Single Bench, my case has been declined on the ground that
you are given liberty to assail the said order dated 20th March 2017, for which you prefer the present.
And the second writ petition was filed challenging that order.
That order.
Yes. But in the finality of the judgment of the second writ petition, my case was declined on the ground that, having regard to the factual scenario under the aforesaid concept of the legal position, the argument advanced by Sri Prasanta Mahapatra on counsel for advert to explain that the benefit of revised pension treating sanitary inspector as per with the multiple.
Which paragraph you are placing?
Paragraph 16.2 as page number 80 of the writ appeal.
Page number 80.
Page 80. 80.
Yes.
The having regard
12.6.
12.6.
Yes.
Yes. Having regard to the factual scenario and under the aforesaid capital legal position, the argument advanced by Prasanta Mahapatra on counsel advocate for the petitioner extend the benefit of revised pension treating the sanitary inspector as per with the multipurpose health supervisor is hereby negated. The concept of the second writ petition, the judgment in the second writ petition is that the petitioner has not retired from the post of sanitary, from the post of multipurpose health worker supervisor.
But sanitary inspector.
But my contention is that throughout the record, it is proved that the petitioner was initially appointed as sanitary inspector, but subsequently that post was amalgamated and the designation was changed at a different point of time. Ultimately, at the time of retirement, he retired from the post of multipurpose health supervisor. To that, I may draw your kind attention to 1 to 2, 3 documents.
Yes.
The document number 1, my retirement notice.
That was annexed to the writ petition as annexed. That was annexed to the writ petition as annexer.
To the which is writ petition annexer 14 series.
14 series.
14 series, page number 57.
Yes. That at the time of retirement,
Yes.
the petitioner was continuing as multipurpose
Health supervisor.
Yes.
So my submission is two.
Please.
First of all, the notice, the so-called notice.
Your submission is that at the time of retirement, he was continuing as multipurpose
Health supervisor.
Yes. To demonstrate that those documents were annexed to the writ petition as annexer 14 series,
Yes.
those were not taken into consideration by the learned single judge.
Yes.
So please demonstrate from that document.
Yes. Page number 57.
Yes.
Page number 57. This is to certify that Sri Lokanath Mahapatra, the petitioner, is successfully completed.
The PHC Puri is successfully completed the MPW training.
That means multipurpose worker training held on 8/12/2080 to 24/12/80 at RSC.
That shows that you underwent training. You underwent a training.
Yes,
But where is the designation?
when I was continuing as a sanitary inspector, I was deputed to undergo a training in a medical institution for the purpose of multi-purpose worker. Then, in capacity of my sanitary inspector, I was upgraded and absorbed in the post of multi-purpose
Where is that?
health supervisor. The next page, 58. As per the order dated 3361 of 2094, Chief District Medical Officer Noyagad, Sri Lokanath Mahapatra, sanitary inspector, bracketed MPHS male of this PHC is hereby retired with his duties with effect from 30th/6/1994 AM. So my initial posting was sanitary inspector, and at the time of retirement, I was designated as multi-purpose health supervisor.
Who designated?
Pardon?
Who designated? Who has authority to redesignate?
My appointing authority, Director of Health Services.
Did he do that?
It is as per the direction of the Director of Health
Where is
Services.
that direction?
Pardon?
Where is that direction?
Achha. The relief order was issued as per the direction of the Director of Health Services. And as per that letter, they have mentioned that I was in MPHS male at the time of my retirement.
No, who is the authority to redesignate the post? Whether that authority
it is altogether with the system that all the persons working in the system, the head is the government, the Secretary of Health Services, and the Director of Health is the intermediate authority.
Where is that redesignation order?
It is not exactly redesignation, but they have been
You must have pleaded so in the writ petition.
Yes.
How it was dealt in the counter. It must have been disputed that you are never redesignated. Please demonstrate.
I'll come to that point.
You have to come fast to meet that point.
Yes.
Then we'll proceed further. That's the only point.
Another point. Only
Another point हुआ क्या?
one annexure.
Please show us the specific argument to the said effect in your writ petition, in which para you have stated so, and how it was dealt in the counter by the opposite party.
Before that, I may permit just one point.
Point wise point जाऊँगा तो आप कहीं confuse होते हैं, हमको confuse करोगे. Point wise जाते. We are not in a hurry, sir.
Sir,
We'll give you patient hearing. But आप point raise कर ले.
Yeah.
And तक meet न करें, आपको कहीं जाओ.
No. On that point, I want to show another document.
नहीं.
That is Annexure 2 of the writ appeal. Annexure 2 of the writ appeal. Page number 83.
Payment order.
Page number 83.
Yes.
In my service book, it was written at the left side of the
Yes.
MPS mail. My pay has been stated, designating me as multi-purpose health supervisor. This
was part of the writ petition, this document. Or for the first time you have annexed this.
This is I have added in the writ appeal. In the three documents I have annexed in the writ petition.
But this document was never
Before the learned single.
before this one.
Three documents. Another document was there in the writ petition also. Another document.
This is whose endorsement it is in that pension payment order? This is found, na? Whose endorsement it is?
That the seal is illegible. The seal put behind below the second endorsement is illegible. Since there is a seal, but that's not legible.
In the previous writ petition, there is another document on the same line. That is page number 47 of the previous.
ଆପଣ ଶୁଣନ୍ତୁ, ଗୋଟେ previous writ petition ଆମେ ଦେଖୁଥିଲୁ, ଗୋଟେ ପରେ ଗୋଟିଏ ଦେଖିଥାନ୍ତି, ତାପରେ writ appeal କରିଥାନ୍ତି.
Maybe pardon for that. But in the writ appeal also, in the writ petition also,
Which page?
page number 47.
The writ petitioner को गोटे document से देखिए after writ appeal. Have you explained in the writ appeal why you could not produce that document before the
only except the service book, I have annexed all other documents in the writ petition.
The reason in the writ appeal as to why it could not be brought on record before disposal of the writ petition. Why the additional document should be accepted by this court at this junction?
Leaving apart that document, 3 documents are there.
Answer for you are not willing to answer the query made by this court. Avoiding.
Now, when a contrary view was taken,
yes, go next document.
Page 47.
Yes, 47, annexer.
Annexer 8 of the writ petition, previous writ petition.
Yes.
The PPO, it is a letter from the Chief District Medical Officer Noyagada,
Yes.
under whom I was working till my date of retirement.
Because retired as MPHS and for fixation.
PPO number 8 of Loknath Mahapatra.
No,
This is-
who treated you as such is not much relevant unless those who treated have authority to redesignate. How rest of the people have been treated who were working like you, how they have been treated in the department.
This is a letter addressed to the accountant
Of the
general.
CDMO. Addressed to the accountant
I
general.
was serving under the CDMO.
CDMO is your
Authority. My authority.
appointing authority.
Yes.
No, CDMO is not the appointing authority. You said director is the appointing authority.
Appointing authority is director, but in direction of the director, the actions are being taken by the CDMO. Because we are very employees.
Third learned counsel for the appellant. We are primacy of the view that the appellant has a case, has made out a case for intervention so far as the improved judgment dated 1/7/2020 passed in WPC number 34311 of 2024, which is under challenge. Yes, State Council.
Well,
Since learned counsels for the state, you are AGA.
my lords,
Accepts notice on behalf of the respondents and admits to have received.
my lords,
Have you received copy of the writ of case?
yes, my lord. My lords.
And admits to have copy of the writ of case? Yes.
Opposite party
Would you like
number
to file
5,
your-
5 notice should go, my lords. Opposite party number 5.
Respondent number 1 to 5.
1 to 4 I appear.
1 to 4.
Notice to 5.
Who is
Notice to 5.
Principal Accountant General? There is a separate panel of law. That's 1 to 4. That is the receipt of the report. If you notice to the respondent number 5 by registers of 3/4/80 on admission, requisite be filed by Monday. So, student fix and then we can see the past specific date since this bench has been found. Dismissal. Yes, so we have to fix a date. In all the circumstances and this is down to the rest of them. Matter Minister on 12th September 2025. Writing record of notice to the respondent number 5 be kept on record before the next appeal. You should notice on why you have filed an IA? What is your prayer in the IA?
Previously, delay condonation, that part has been open.
Delay has been condoned.
Yes, in previous order.
Yes, my lords. 4/7/25 it is on those. My lord, item 2.
Let me look to this judgment because on last occasion 8/7, your lordship to heard the matter. Lordship said in the other case, of course, my lord was sitting with my justice now. My lord Justice Mishra is here. This case is, in fact, they were appointed way back in 2010 pursuant to an advertisement, and the posts were created and sanctioned. They are governed under 13, they dealt with under 13, and you also dealt with that. On that day, you also said that since we are delivering a judgment in another case, you please wait till the judgment comes. That is why it has come.
Let us see what
My lords, my lords, I have to see whether this is similar to this or not. That record is not there. That is why.
on the same day we'll call so that
My lords.
As stated by the Honorable Counsel for the state respondent, the matter will state.
The state is also appellate.
There are two appeals, one by state and another.
The matter will issue on 12th September 2025 along with the connected appeal on board.
Yes.
Item 3. In item number 3, I am for the petition, my lord. I am not too well, my lord. You can include any date, your lordship. Next week, any date, lordship. I am not well.
Not a part of it. It's okay.
The submitting that is not well.
Only on submitting matter. And last order sheet, I can say 3 times it has been listed. Now what happened, my lord? This is the order challenging the order of the Central Administrative Tribunal Court. The land outage who wants an appointment, their items in 92, 93 lands were acquired. Matter went up to Supreme Court. Then again, we are moving in second round by the CAT and thereafter this. Then, although it is a new case, the mother faction is very old. Only I pray. Now some additional affidavit filed today. Let it be.
Any date, last chance, my lord, any date, lordship.
Taken up only 15 people, only one point is there, one legal point is there.
Yes, it's only one point is there.
It will be infrastructure. Why they will fight up to Supreme Court again remanded again? Because that is this way.
but he is asking for adjournment on health ground.
Last time also,
No, my lord, last time.
last time also this time prayer. He has filed some additional
Just a
affidavit.
moment, sir.
Now he has filed additional affidavit. Now my
Learned counsel to the petitioner appears to virtual mode and prays for an adjournment on the ground of his ailment. The matter will be listed on 22nd August 2025. 22 तारीख short date फिलहाल में September अपन ना सुनिए you have already
petition दिया है.
Learned counsel for the basic learned senior counsel being assisted by
A. Sigdar, or B. Sigdar.
Is present and submit though Mr. Sigdar submits that though he has rendered appearance representing the opposite party is not, his name is not reflected in the cause list. Office is directed to do the needful. Matter listed to answer.
Item 4.
अपना take up on peremptory on that day.
Again?
They do not peremptory न्याय.
पर ଆମର ଏଟା ସ୍ପେଶାଲ ବେଞ୍ଚ 22 ତାରିଖ ଫିକ୍ସ ହେଲା ଆଉ ପେରେଣ୍ଟରି ଆଉ କୋଣ ଦି ଚାରଟା ମ୍ୟାଟର ବି ପେରେଣ୍ଟରି ଅର୍ଡର କରିବା अब ଆମେ we remember your anxiety.
My clients
It is being demonstrated before us through you only. We don't know your client. We have no opportunity to see your client. Our anxiety can only be.
yeah, that is there. That's not mine. That's
Item 4.
My lords, item 4, there is a application for condonation of delay. That is IA 516 of 2023.
Notice is to go.
Notice,
I have already
my
applied.
friend,
Last time also had the matter extensively. I could not bench.
How many days delay?
72 days, 472 days, my lord.
Subject to payment of cost.
I am only submitting. Two review petitions. One is already dismissed by the criminal bench. These are only
On the last occasion, the division bench had advised you to prepare detailed rate chart.
So director,
The series of litigations.
no, only two litigations.
I distinctly remember being part of that bench.
Madam.
You were advised to prepare a detailed rate chart. Have you prepared the same or not? ना भूलिगले तो
And I have filed the counter.
काउंटर कथा हम जाननु आपण काउंटर मैं आपण पचारछु डेट चार्टटा करिसंती कि ना काई गलेनी
जेहेतु लक्ष्य
कहिथिल ना नाही मु सेदिन भी कहिथिल सभा तळर कथा कहू
लक्ष्य डायरेक्टर टू फाइल द रिव्यू ऑर्डर ऑफ रिव्यू petition. That I have brought.
No, make a compilation of all the orders, so also prepare a date chart to assist the court. Your submission is that issue has attained finality. So, but in view of the judgment passed by a coordinate bench, the state has preferred this review application. The very basis to prefer the review application because of the view taken by the coordinate bench.
My lord. The very same issue has been adjudicated by the coordinate.
Otherwise,
my lord.
Yes.
Not sorry, madam. The very same issue, on a single judge of
Single bench.
Single bench. Not mine. But the revision bench dismissed the repeat petition. After the appeals also dismissed the SLP.
In view of the submission, that's in similar cases, the Supreme Court, dismissed the SLP preferred by the state.
Mine.
On the ground of delay, my lord.
No.
On the ground of delay.
No, on the merit also. My review petition, my reply. The same order, in common order on tribunal.
ଆପଣ ପ୍ରିପେୟାର କରିକି ଆଣନ୍ତୁ ଡେଟ୍ ଚାର୍ଟ ପୁରା ସବୁ ଅର୍ଡର ଗୁଡା କମ୍ପାଇଲେସନ କରିବେ with an index also date chart ଆସିବ 12 ରେ ଆସିବ as per the council for the
my lord delay will be
ରୁହନ୍ତୁ ଡିଲେ ଟା କଣ୍ଡନ ଯଦି ମେରିଟ ରେ କିଛି ଥିବ ଡିଲେ କଣ୍ଡନ କରିବ
yes my
ମେରିଟ ରେ ଯଦି କିଛି ଥିବ
my lord
we may think of
my lord
matter listed on 12 September.
Petitioner is a widow lady whose husband died in harness in the year 1960. My lords, but
Died in 1960.
yes, my lords. But
I was not born. You were not born. Died in 1960.
yes, my lords.
And then what?
My lords, but yet she has not been given pension. Pensionary benefits she has not been given.
Family
Yet.
pension is not given.
No, my lords. I pray, my lords, any day next week. My
Next week. Yes.
Petitioner challenge the illegal order of the authority, my lord. Authority has preventing to perform his duty, my lord. That, my lord, in this notice.
Yes. It's a fresh admission matter, your lordship. Matter regarding to grant of increment, your lordship, which I will, yes. Your lordship, 2022 matter. Petitioner's prayer is for grant of pension.
Lordship, the father of the petitioner died in 2013. 13.
Compassionate appointment.
Yes, my lord.
Speak on.
Let's matter relating to denial of to advance increment.
Advance increment.
Let's
3 weeks.
Item 36, madam. Yesterday, I have filed rejoinder. Kindly taken up next week or 1 week after.
Which year matter?
25.
25.
I have taken consent of
the other side.
In terms of the
You
other.
call it in the second week of September.
Interim order is there, interim order to continue.
Interim order.
Item 1.
May please launch.
Yes, sister.
Can you please launch? Let's check what has happened in this case, Millards. The petitioner are the permanent resident of a village, Ainginia, which is nearer to Bhubaneswar, Millards. What has happened? There is no passage or there is no road to their residential area.
Repeat.
They are the permanent residents of the village Ainginia near Bhubaneswar, Millards. So what has happened in this case? My prayer is, Millards, that there is no way, there is no path to the residential house of the petitioner. In previous state petition, Millards, the government has given one joint affidavit report saying that there are 2 adjacent plots in which the petitioner can use that plot for their ingress and outrace. But my difficulty is that, Millards, both the plots that the government have undertaken, Millards, both the plots belong to the private persons.
He is not permitted.
No. So the private person, how I can use their land for my entrance or for my ingress and outrage?
Then you better buy one helicopter so that from outside you can go and land there. No entry at all.
Millards, yes, Millards. What has happened? There is a cremation ground at plot number 348, which is adjacent. That cremation ground is, Millards, is being used by the residents of that area for their day-to-day life. Now, what happened in that cremation ground, Millards? They are constructing a permanent boundary wall. So that because
once that is constructed, you will not have access at all.
Yes, Millards.
Who? For the first time it has come.
No, Millards. Previously, it was listed in 2024.
And the layout was formed by whom?
BMC. Bhubaneswar Municipal Corporation.
Is it?
Yes, Millards.
What do you say?
For the state to take instructional decisions.
But kindly see the order. No further adjournment shall be granted. Suppose if you put up a wall, how they should have ingress and egress to that particular area?
Municipality, Bhubaneswar municipality is putting up the wall.
It is putting up the wall now.
Yes.
Has it put up the wall now?
No, Millards, the construction we have
started.
No.
Then we'll ask who is your opponent?
BMC is the opponent party, Millards, and they have a separate council of pen.
Get one more combination. Special missions issue notice.
Notice to OP 3 and 4.
AGA for
1 and 2.
1 and 2. Emergent notice to 3 and 4. Returnable within 2 weeks. Post immediately after service.
Millards, may I plead that I have filed one IA that the construction is not to be taken in the.
But you said that construction site is still free.
Though it's free by now, but
Petitioner is permitted to move appropriate memo in the event urgency arises for consideration of interim application.
Great, Millards.
Yes, next.
Item 2.
Item 2, my lord, on behalf of S.K. Das, pass over, my lord.
Pass over?
Yes.
Yes.
Item 3.
Yeah. That's it. This matter about none appears for the petitioner. Call number 2, 3 weeks.
Item 4.
May I please, your lordship?
Yes.
My lord, on behalf of Mr. P.K. Sotpur, I am permitted to place the matter, my lord. My lord, what was happening in this case, my lord, the opposite party number 7, without giving any opportunity of hearing to the petitioner, my lord, is going to be constructed, as construction work has already started, my lord, over the petition's recorded land without following the due process.
That unauthorized utilization of petitioner's recorded land
My lord, the
for
land
making
belongs to the
construction of Pakka road and direct the collector also to consider the grievance for change of alignment. Where is your representation?
my representation is, my lord, annexure
1.
1.
Let them consider that.
Yes.
My lord.
Perfect. Petitioner is complaining not as to non-consideration of his representation. Dated
The petition dated, my lord, page 7, my lord.
3rd July.
3rd July 2025, my lord.
3/7/2025. Wherein broadly he has sought for holding of inquiry regarding unauthorized utilization of his land
My lord.
for making construction of Pakka road therein, and also to consider his request for change of alignment by using the government land instead of his.
My lord.
First of all, he also seeks payment of compensation, SIC, into bracket damages, as per law for using his land. First of all. Next paragraph. Learned counsel for the petitioner submits that when a citizen makes grievance by making a representation, the same is entitled to be considered by the answering opposite parties, and that having not been done, this court should come to the aid of his client. First, there is some force in this submission, inasmuch as learned the AGA appearing for the official respondent says that the representation shall be considered in a time-bound way, and results thereof would be conveyed to the petitioner if all contentions are kept open. First, next paragraph. In the above circumstances, the petition is disposed of. Time for consideration, which would include informing result of such consideration, is 8 weeks. First one, all contentions are kept open. Next paragraph. It is open to solicit. Well, copy to be obtained upon. In every order, you should write that, because there is some complaint saying that the certified copy is not being given despite lot of time. So, all parties to act upon the web copy.
My lord, more particularly the OP number 3, my lord.
OP number 3.
3,
we have
collector.
jurisdictional.
My lord, may I pray one thing, my lord, till disposal of my representation not to construct. My lord, I have filed one IA, my lord.
That cannot be given. Yes. IA appeals into insignificance in view of disposal of the main matter itself. Okay. No cause.
Item 5.
My lord, this matter covered by the judgment passing.
What is that? A few facts you should say. Then you should say covered by the judgment. What is this matter about?
Petitioner is not allowed RSC from the date of joining.
From date of joining?
From the date of joining.
Where is your representation?
Representation is not there.
Then without making representation, how can we direct them?
This is all the way that Ashok Maptra judgment which has been fixed to next week, my lord. That the higher should be met.
You accept notice. AGA on request accept notice for all respondents. Which respondent?
Respondent number 3.
Why you are so much hesitant to argue? Be jubilant in the morning at least. All respondents. Call this matter in first week of September 2025. Yes, next.
Item 3.
6 is same, my lord. Your my lord, so far the opposite parties are concerned. D 1 to 3 men.
1, 2, 3.
Yes.
Any other OP is there?
No, my lord.
Same.
Much obliged.
Item 7.
Please tell Lord similar. The second round litigation, my lord, challenging Annexure 8, page
What is your
28.
prayer? Let us see the prayer.
The prayer is, my lord, some certain period of area dues, they have not paid to the petitioner, my lord. Though the other income has already been paid. So I challenge that earlier, my lord. But as per the
Arrears of salary.
yes, I have some the salary from duty period salary from 1/11/2018 to
2/10/2019.
So the
office order dated so and so.
So the facts is like that, my lord.
No, I'm asking you, have you made a representation?
I have made a representation and it was
rejected?
disallowed.
Disallowed. Where is that order?
That order is in Annexure 8, page 28. Go to that. Page 28. They say that these are the periods, my lord. Though the school was declared derecognized, my lord, and they have adjusted in another schools, so that periods, duty period salary they have not paid. They issue notional, but we are in 8 numbers of staffs. So all the staffs separately filed the petition before the authority. Then after that, my lord, the director issued a letter to the DO issued a letter by Yellowstone turn to page 23, Annexure 6. This is a letter of the DO Niagara to the director regarding the this period salary, my lord. But though the director has not passed the order, then I will make representation before the director separately and file the representation separately. One Minakinanda case, that order was issued, but they allowed her salary. But in my case, they disallowed. And in the Minakinanda case, my lord, also, the government also filed a writ appeal. The writ appeal was dismissed.
Sure. Learned AG is requested to accept notice for respondents.
Your Lordship, I can say another 2 persons filed the cases. Your Lordship, issue notice issued. And they already issued.
Call this matter along with the
date was fixed.
WP number. So in the second week of 2 others you have already given. And your challenge before the division bench failed. To him we have discriminated. Yes, next.
Item 8.
May I take the Lordship?
Yes.
The petitioner here under they are challenging Annexure 8, and so also they are praying for the benefit of pension and other ancillary benefits in terms of Vitanjali Giri. Lordship, kindly see Annexure 7.
Take notice.
My lords.
That whether that matter went to Supreme Court in that? In Vitanjali Giri matter?
Yes, Your Lordship. They were confirmed in Supreme Court, Your Lordship.
But that notice, AG accepts notice for any private party?
No, Your Lordship.
No.
Item 9.
I'm grateful.
Item 9, my lord, petitioner's prayer is for grant of benefit of UGC scale of pay and the consequential benefits, my lord.
Similar matters we have admitted.
Admitted and notices in
AG issue notice. AG is required to accept notice. Call it the 3rd week September?
Yes.
3rd week of September.
My lord, in this case, representation is pending, my lord.
Pending?
Yes, my lord.
If direction is given for
yes, my lord, because the petitioner. Yes, my lord. Because in the meantime, in
Because,
February 2025, they have granted the UG scale of pay to the similar footing persons.
So let them consider your representation.
Prior to this case, my lord,
Annexure 7.
prior to this case, the petitioner's father had approached this honorable court via Annexure 3. Same prayer, my lord. Thereafter, my lord, he died.
So now his LRs are seeking that.
Yes, ma'am.
Yes.
Petitioners, one petitioner.
Petitioners, ma'am.
Being
No, my lord,
the-
two.
Being the LRs of deceased, what was he, professor?
Retired demonstrator in zoology, ma'am.
Deceased demonstrator who was, according to comma, petitioners, was entitled to a particular UGC scale of pay, are grieving that their representation in that connection made, comma, remains unconsidered. First off, representation is dated
10-3. 10-3-2002.
10/3/2025, remains unconsidered. Date you can put there. First off, next sentence, similar, we can put. The representation is going to be considered in your Article 350 of the Constitution. Next paragraph. Learned AGA appearing for the respondents, having resisted the petition for some time, agrees that the representation merits consideration at the hands of jurisdictional authorities, and accordingly he would instruct them to do their task in accordance with law and in a time-bound way. First off, this is appreciable. Next part, we talk about writ petition is disposed of. Then same sentence, time for complaint, print it same. Open to solicit information, etc.
My lord, I'm taking it off.
One sentence you can say. The consideration should happen in the light of
In Annexure 2 and 3, my lord.
annexures, documents at annexures 2 and
Item 10.
petitions kept to. Judgment that way.
Please tell Lordship, this
Yes.
is also a second round litigation, my lord.
Ah.
I have challenged Annexure 8, page 44. Page 44. Here the case, my lord. First I appointed as Gana Sikha. Thereafter Sikha Sahayaka. After 3 years, again I promoted to the post of junior teacher. Then after 3 years also,
That representation is rejected now.
rejected by the, page 44.
What was
Annexure
the-
8.
what you had sought for in
My question is that Ganashikya period has not been counted for promotion to the post of regular primary school teacher. I have filed in the representation that my case is covered with the Dhananjay case, Miller. Because in the Dhananjay case, Miller, page 33, your Lordship may kindly see that it was a challenge by the state before the Honorable Apex Court. Apex Court also dismissed their SLP. Then your Lordship may turn to page
you have put in 6 years of continuous service.
Yes, Miller.
Then on 6 after lapse of that, you become regular assistant teacher.
Yes. Now I know, but that Ganashikya period they have not counted. So my service, I am not getting that.
Notice. Well, we have a similar matter. Actually.
Similar matter, but here so far the rejection is concerned, there it is concerned to that qualification of that city. Let notice be issued, we will file the counter.
Issue emergent notice. Mr. Mohanty accepts notice for the respondent. Put this matter in the third week of October. Yes.
11.
My lord.
Yeah.
My lord, this is the second round of litigation. My lord, here the petitioner was appointed against a post of Group D post on a contractual basis. After that, he continued in service for long 8 years on contractual basis. Then later in 2019, the opposite parties were about to create some post. So he approached this honorable court in WPC number 2734 of 2019. In this matter, after that, the court initially issued notice while directed interim measure not to fill up that post for unreserved category. After that, in January 2025, the writ petition was disposed of while granting liberty to the petitioner to file a fresh representation before the opposite parties. Then after that, the representation was rejected And my lord,
Rejected on what ground? 5 grounds.
my lord,
they have
all the
given.
grounds are similar to the Jago judgment, 2024. My lord, I will solve a copy.
We have that copy with us.
Yes, my lord. My lord,
But
yes.
they have given 5 reasons. Come to page number 43. You showed prima facie that these reasons are unsustainable.
Yes, my lord.
You have been engaged through outsourcing agency.
Yes, my lord.
Huh? How Jago will come to you? Where is the vinculum juris of
My
employer
lord,
employee?
similar matter was listed yesterday.
Huh?
And my lord was
Notice is issued.
yes, my lord. Notice was issued.
That matter also should have been dismissed then.
My lord,
Along with
I will
this.
give the writ petition number. Yesterday, item 39, WPC number
Issue.
21637 of 25.
University is the respondent.
Yes, my lord. State is not a party.
Issue emergent notice. In addition to taking usual steps, petitioner is permitted to serve copy of the petition along with all documents on the panel counsel who usually represents the university.
My lord, I'm
Okay.
filing an IA.
Call this matter in the 3rd week of October 20.
My lord, I'm filing an IA that one post may be kept vacant for the unreserved category.
First one, please. Next, one more point before that. Learned counsel for the petitioner submits that in an identical matter like this in WP number
21637 of 25.
21637 of 2025, an interim leave is granted, directing the university to keep one post vacant so that in the event petitioner succeeds, he can avail the vacancy. First off, in view of that, similar order needs to be and accordingly is granted in this matter as well. First off, call this matter along with the WP person. So that's definitely not good because in that will be application filed in the open court with leave is taken on the one sentence. Interim order to be acted, reverse copy to be acted upon. You print that in every order. Tell other stenographers also. Because there is a complaint saying that for many days we don't get the order itself. Certified copy. Okay.
Item 2N.
In fact, my innocuous prayer is to allow grant me liberty to make a representation. You also come to page 130. A similar matter, you also have disposed of the representation. Now government has taken action. Only my request is you also direct them to permit me to make a representation. Though I have made the representation, my representation is not available. Page 130. Similar, exactly similar case, you will also be directed, a coordinate page, directed to consider his case. 130. Annex 14.
But their representation was given.
Was given. Here it was given, but the whole problem is that is not being traced out. So I will be permitted to make a representation again.
What is that representation to be considered in this?
Consider from the date of my initial appointment, I am entitled to get.
Regularization.
Yes, from that latter date they have given. In fact, if you also look to page 132 at Annex 15, in that case where in S.K.MISHRA's case, they also are directed to consider. They have considered and they are going to take a conscious decision after hearing it. And that decision is at page 54. 157. Page 132 starts, page 137.
The short grievance of the petitioner is as to non-granting of antedated regularization. Granting it.
Granting it. Also say granting it. By way of granting it.
It's a regularization only.
Regularization by way
of granting, by way of admitting the institution to the granting. Institution or post?
The post. Post
to the granting.
Under GIA order 1994.
In terms of order GIA order dated
1694, that is called GIA order 94.
16/1994. A copy whereof avails at an excerpt
That is, that rule has not been given. This is manual, it is in the banner.
Learned senior advocate appearing for the petitioner submits that it has been a settled position of law because of precedents availing in the realm that such a relief has to be granted by the concerned jurisdictional OP, and that having not been done, the petitioner is tapping the jurisdiction of this court.
So refer to that order, that S.K.MISHRA's order at Annexure 14.
He also places reliance on a coordinate bench decision in WP number
16366
16366 of 2022, disposing of the Mishra versus state and others, disposed of on 12/9/2022, wherein a direction has been issued to consider request of the litigant in the said case
after granting opportunity.
The benefit. First one. Next paragraph. Learned ASC on request having accepted notice for the respondents. Please be seated. Respondents opposes the petition contending that ordinarily a writ of mandamus is not granted unless proof of demand and rejection is put on record. First off, there is force in this submission. First off, having so contended, now he submits that if the petitioner makes an appropriate application in the prescribed form, along with the vouching documents for his claim, there would be no difficulty for considering the same in a time-bound way and in terms of extent and policy, if all contentions of the parties are kept open. First off, this is fair enough. Next paragraph. In the above circumstances, the petition is disposed of, reserving liberty to the petitioner to make an appropriate representation, airing his grievance as has been done in the writ petition. And if one is made, the jurisdictional authorities shall consider the same in accordance with law within an outer limit of 8 weeks, which would include informing result of consideration.
In the light of Annexure 15. In the light of Annexure 15.
Keeping in view the document at Annexure A.
Annexure 15.
Annexure 15. Annexure 15. First,
in case of S.K.MISHRA.
No, they have said that.
Yeah, that you also already said.
In keeping in view the cognate decision of coordinate bench. First, all contentions are kept open. Last, it is open to the answering respondents to solicit any information or documents from the side of the petitioner as are required for due consideration of the representation in contemplation. You make representation in 2
weeks.
3 weeks.
2 weeks.
2 weeks.
An opportunity of hearing. In that case also said.
No, we do not know how that will.
Item 13.
Yes.
Relating to release of differential salary in ORSP Rule 2017, my lord.
Differential salary.
Differential salary.
For the period.
My lord.
For the period.
Period 1/1/2016 to the
1/1/2016 to
9/2017. 30th September 2017.
Similar matter we treated day before yesterday, na? Have you given the representation?
Yes, my lord. I given the representation.
Rejected?
That is rejected.
On what ground?
The ground that is the paucity of funds. The paucity of the funds, they have not released. Your lordship kindly see that this thing, my lord, also arises before this honorable in case of the Tirai case. That is, they have gone to Supreme Court. Supreme Court dismissed the appeal and directed to implement the revised scale of pay. That is the fifth revised scale of pay.
Do you accept notice, brother?
Your Lordship,
Rejection already there.
Huh?
Rejection already there.
Therefore, you have to file objection.
Yes,
There is
my-
rejection order.
yes, Alex Ray. Only my I pray.
ASC is requested to accept notice for the respondent. Full stop. Since a short point is involved, call this matter in the second week of September 2025.
Well, with the Lordship's permission, my lord. There is batch of cases filed.
That list.
The one case, the pleadings are completed. A counter, rejoinder, everything is ready, my lord.
Give that case.
That is,
All cases you give. I will post them and finish off by one stroke of pen.
my lord, 10414 of 2024. Fix a short date, my lord, because the all other retired persons.
That means you should not push the judge to the corner. There are many other.
No, my son. 10414 of
Other matters also you give the.
yes, I along with that matter also.
Item
Then,
13.
well, in those matters, the date is not fixed.
The date fixed about 22nd of March. Thereafter, my matter is not listed, my lord.
In second week of September, we do.
My lord.
Item 13.
Petitionary, a retired teacher from an aided educational institution, served more than 33 years.
Huh?
GIA pension
Third week we have posted. Issue a merchant notice. Call this matter in third week of September. AGA accepts notice.
I am claiming pension matter.
GIA pension.
Same matter. 11/8 it is posted. Similar matters is being Justice Mishra Sahib is speaking. Na? Yes. Yes.
Item 15.
It lost. My lord, petitioner is the richest scholar under Annexure 1 IIT Kharagpur, my lord. During his he applied for the Annexure 2 and he was selected SSB candidate as lecturer at serial number 45, page 13, my lord.
What's your prayer?
Prayer, my lord, I want to go on leave, which was accepted by the authority. Lord, you may see that. Annexure 4, page 18.
You wanted to go on
No,
leave.
leave to complete for thesis and other works in
Sabbatical.
Yes, my lord. That is Annexure 4. Lord, you may see that. At the time of joining, NOC has been given to complete my course, my lord.
Higher studies.
Yes, my lord. Yes, authority has granted, my lord.
Where is the date for this?
My lord, Lord, you may see my representation under Annexure 5 series, page 19. I required leave from 10 August 25 to 31st July 2026.
That too without pay.
I'm agreed for all, my lord.
You will not.
Without pay, even if I will not receive any salary here, I may get the, my lord, that
stipend you will
yes,
get there.
yes.
Why, brother, you have agreed to give and now you are saying not to.
At the time of appointment, they have given this NOC.
That NOC given by the
And without pay also.
Yes.
That NOC given by the
As
principal
per
of the
direction.
One second.
Lordship kindly see page 22, my lord.
22.
22, my lord.
Go to 22. Yes.
And the principal also recommended the petitioner's case, my lord. Lordship kindly see paragraph 2, my lord. The Department of Commerce consists of
3 regular lectures.
out of
which one post
one
is
post
lying
is lying
vacant
vacant.
for last 1 year.
my lord.
At this juncture, if Mr. Malik is allowed with leave, it will be difficult to manage the classes for 522 students, including both +2 and degree. Yes.
If it is so, my lord, then how this principal has issued this NOC under Annexure?
That's all right. Question is not that.
That is, guest lectures are there, my lord. Now they are playing hide and seek with me.
No, yes. Interest. See, as between, we are operating, our whole system is founded on greatest good of the greatest number of people. Benthamism, Jeremy Bentham, the great author of Theory of Legislation and Morals. The greatest happiness of greatest number of people. The greatest number of people, 522 students.
Well,
Their career cannot be affected. to favor you.
No, that's there, my lord.
After all, sabbatical is not a matter of right.
Well, that is, my lord, other guest lectures are there, my lord.
Sir, they are taken.
Well, at the time of, my lord, entry into this service, that has been taken care of by the authority, which he has written, my lord, in Annexure 7.
Interest of the students. See,
but we are taking the advantage of that leave, my lord. But in fact, there is guest lectures are therein. They can keep also leave vacancy.
The grievance of the petitioner is as to non-sanctioning of sabbatical leave for making value additions. Sit down. Sit down. Sit down. First one. Next paragraph. Learned counsel appearing for the petitioner draws attention of the court to the letter issued by the principal of the institution dated 18/3/2024, a copy whereof avails at Annexure 4. First one. Next paragraph. One more sentence. He submits that value addition would be helpful even to the institution itself, so that he can be more effective in instructing the community of thought after he returns, post making such value addition. First one. Therefore, he seeks a direction at the hands of this court to facilitate him to avail the leave, that too without salary, and emoluments. First one. Next paragraph. Learned ASC, on request appearing for the respondents, opposes the petition, contending that there is a dearth of teaching staff when in the institution as many as 522 students have been studying, and therefore, as a matter of right, sabbatical leave cannot be availed. First off, in answer, learned counsel for the petitioner submits that there are members of guest faculty who would look after the eventuality, and therefore his client should be permitted to go for pursuing PhD. First off. Next paragraph. Having heard the learned counsel for the parties and having perused the petition papers, this court is broadly in agreement with the submission of learned ASC that the availment of sabbatical leave for making value addition cannot be claimed as a matter of right when one is in an educational institution. First off, the value addition is desirable, is true. First off, however, that cannot be at the cost of the community of the thought. First off, next paragraph. In the above circumstances, the petition is being devoid of merits, is liable to be, and accordingly rejected, costs having been made easy. First off. However, this order shall not come in the way of petitioner seeking a sabbatical leave when the staff strength becomes sufficient in future.
My lord, one thing I pray, one thing I pray.
Please.
My lord, the petition approached the authority. Now authority has given the reply, you send all papers so that we will be considered by the secretary, my lord, OP number 1. So Lordship may issue notice for the...
No, that becomes difficult to the students. We have structured...
that is there.
One sentence you have to add. Our system broadly operates on the principle of Benthamism, that is, greatest good of greatest number of people, and therefore individual interest has to be subservient to the greater interest, which Jeremy Bentham said in his theory of legislation and morals. One sentence of that.
Item 16.
May I please?
Yes.
Well, the petitioner is working at level B senior teacher in the elementary cadre. Here the petitioner challenged the order dated 25/7/2025 issued by the BO, wherein the petitioner has been transferred from government upper primary school Mundagaon to government primary school.
How many kilometers?
Well, kilometers, 40 kilometers.
40.
Yes, my lord. But this order has been passed in violation of the transport guidelines, my lord.
Which is that?
Yes, my lord.
But you have given KDA, etc. also.
Yes, my lord.
How many years you have been in this institution?
Like 2 years and 6 months.
2 years, 6 months.
6 months, my lord.
What is the retention period?
6 years, my lord.
6 years.
Yes, my lord. As per the transport guidelines. Yes, my lord. Kindly have a glance at Annexure 4.
Slow.
Yes, my lord.
Slow. Be slow.
Yes,
Yeah.
Annexure 4, page 16, my lord.
This is what?
It starts from page 16. Lord, the relevant page is page 22.
These guidelines have statutory force?
Well, all the transport matters from 14/5/2025 are based on these guidelines only, my lord.
This is not that 15% MLA, etc.
No, my lord, no. My lord, kindly have a glance at page 22.
22.
Yes, my lord. Transfer on resignation, my lord. The principal, clause 6, my lord.
6 teachers.
Teachers who have completed 6 years of continuous service in one school will be eligible for transfer to another school.
Eligible or liable?
My lord, here they have written eligible.
A teacher who has completed 10 years of continuous service in one school
must be transferred to another school. And my lord, another point here is, my lord, the road strength of the school is 22.
Yeah.
And as per the, my lord, PTR ratio, my lord, next primary school, for 1 to 31 enrollment, 2 teachers are required.
2 teachers.
Yes, my lord.
Even. Yeah, how many students are here?
22.
Therefore,
2 teachers are the requirement, my lord.
There is only 1 teacher now.
2 teachers are there. If I will be transferred, my lord, then there I will be left with only, school will be left with only 1 teacher, my lord.
Issue emergent notice.
May I submit, madam?
Yes.
Only as a senior teacher, he has completed 3 years, my lord. Before he was there in the same blocks for 10 years, my lord.
Same block, but not in the same school.
Not in the same school.
Not in the same school, but in the same block 10 years, my lord.
Let us see. So how it reads. 6 is school specific,
yes,
not block specific. Class 6 is a school specific, not a block specific. It uses the word, see the terminology. Teachers who have completed 6 years of continuous service
in one school would be eligible to another school.
Yes. Therefore, not from one block to another block or one school to another school in the same block. That is not the terminology.
Man.
That you have to suffer because it is your terminology. But issue emergent notice. Learned ASC is requested to accept notice for the official respondents. Full stop. Stay of transfer order for the petitioner till next date of hearing. First stop. This interim order, interim relief has been granted to the petitioner, keeping in view clause Roman capital 2 small 6, which reads as under. First, in addition to that, the PPT ratio is also kept in view, in as much as the school in question will be left with only 1 teacher, which will be in breach of a ratio of 1:31. Okay.
Grateful, madam.
17.
I'm seeking a small indulgence from this honorable court.
Yes.
Annexure 1, Millers, unfortunately, Millers is in Korea. I may be
Unfortunately. Fortunately, in Korea.
Millers, I may be allowed to bring on record, Millers, the English translation so that Millers.
There are two aspects of the matter. Actually, I'm appearing with my friend, in fact. Sir, one document, inadvertently, the notification has been wrongly annexed. The recent notification which is required to be annexed has not been done.
Then you can repair that.
I can rectify that.
Call this matter after 2 weeks.
Next week. Next week, 13th.
Next week. Next week we have many matters.
Okay.
Call after 2 weeks.
Please.
In the meanwhile, whatever repair the pleadings require come up are permitted to be done.
I'm going
Item 37 is connected with this.
With this,
Yes, Father.
call item 37.
Maybe tagged along with this.
That's fine.
Both the matters.
That's fine.
Grateful.
Progress.
Next.
18.
May I please, Your Lordship?
Yes, sir. One thing I should make clear, I give dictation in the open court. They are more in the nature of skeletal, they are skeletal. And thereafter, I make my research again. And the operative portion remains same, but some addition, deletion from the text of the order may happen. All right. This is my standing request to all of you.
But that should not bother anyone because the ultimate
result remains same.
Man.
Yes.
So good. Now here what has happened, now I have a piece of land where I am running a market complex and having also
running a
market complex and also having a hotel. In front of
what
my
complex?
Market complex. I have done multi-building, multi-room building, and I'm running I have let it out and a market complex is being run.
Market complex?
Yes, ma'am.
Okay.
Now what has happened? In front of my land, right in front of my land, there is a Gochar government land.
Gochar?
Government land.
Means?
Gochar means that is grazing of cattle and other things.
Huh?
Grazing of cattle.
Kairan land.
Now that land, even government should not utilize for any other thing. Be that as it may, that is 1217 plot. No, my plot is 1218, 1220. That is the only route available to communicate to the public road. Now what they did, they major portion of my frontage, they raised one-storied shopping complex to let out. Even I challenged it for reasonable court. Just as they said to me, I will demonstrate from photographs and the map. Now I moved reasonable court. Reasonable court was pleased to direct the authority, that is opposite party number 3 in the writ petition, to consider the same. Now authority considers the same and says that no, this building has been done, that is fine. We are not going to have interfere with that or recall it back. But we are giving you a 45 to 50 road.
45 to
50 road.
45
feet to 50 feet road. That means the width is at places 45, at places 50. Okay. Even I don't have any grievance. Now what has happened, why I am before your lordship? So before showing to your lordship my grievance, may I just draw my lord's kind attention to page 18, the map. Only for appreciating the locational features. 1218, my lord, your lordship will see right hand side towards middle, and 1220 is mine.
1218, 1219 is yours.
No, 1218 and 1220.
1220. Both are yours.
1217 is the frontage, which is a Gochar land.
1217.
That front. In front of 1210.
That angular.
Yeah.
Angular land.
Gochar land. Now I submitted it for lordship, that is the only access because I don't have access from 1218 because this frontage is blocked completely. Now they say also, yes, we are giving way 45 to 50 feet road.
Where they will lay that road?
I am just explaining that. That will I will demonstrate from the photograph. Now this 1217, I have said it is Gochar. They should not have done it. Your lordship may kindly come to Annexure 7.
Gochar. Gochar.
G-O-C-H-A-R. Gochar means grazing of cattle and other things.
Go is go.
Yes.
Cow.
Yes, and unless it is converted to any other thing, even the government cannot use it. Because it's reserved for a purpose in terms of survey settlement.
It's a pasture raised land.
Exactly, Your Lordship. So now Your Lordship.
The sacrosanct purpose of gazing of
That's
cattle.
Yes. So be that as it may, they have constructed market complex.
Is for Gomata.
Exactly.
Your Lordship, now Your Lordship sees Annex 7, page 32.
32.
Yes. The top left-hand side photograph. There are 4 photographs. Top left-hand side photograph. Your Lordship sees my wall. Then just adjacent to it, this construction was done market complex. That is, my lord, also I am not objecting to. It could not have been done because they should have left minimum gap in between buildings. That they have not done. They have done it just, Your Lordship sees, by the side of my wall.
Adjoining the wall.
That they have done, my lord, claiming for demolition of that will be a very difficult proposition. That also I don't object. Now, Your Lordship may kindly come to the right-hand side photo. Right-hand side photo top.
Right-hand side photo. What is that?
There are 4 photographs, my lord, in page 32. One, Your Lordship, left-hand side top one, right-hand side top one. In one page, page 32.
Two photographs we have.
There are
half constructed structure is there.
That is fine, my lord. Now, the right-hand side is my grievance. They are building, Your Lordship sees, ends. There is a roof, Your Lordship sees, in the frontage. Right-hand side photograph. Your Lordship sees there is a wall.
Which is your paper, just show me.
My lord, this one. Page 32.
Page 32. You are right.
Right-hand side, Your Lordship has seen. The wall ends. There is a, my lord, roof, Your Lordship sees, portion of roof.
Yes.
That is the frontage of the left-hand side where they have made construction. Now what they are doing, the reaches, Your Lordship sees. Now that 45 road, there is no approval for a reach. The reach, Your Lordship sees, in the floor.
Whether it's a private building or public building?
Only private building. This is a Gochar land. They have made construction, that building. Government has made construction because they are the mighty. That is fine. Now these ridges is encroaching upon that 45 feet. Now they want to block. Your Lordship sees the left bottom photograph. Unpaid, Red Bull, Your Lordship has seen. That building is mine. If in the frontage these ridges are put, then I cannot access.
Left-hand side is your building.
Left-hand side below photograph, Your Lordship sees, my building is at the back. Unpaid, Red Bull, Your Lordship got it, my lord.
Yeah.
Then this frontage building is the government building, market complex. I have no grievance.
Okay.
The wall ends. Then after the wall, these ridges in front of my building, my lord. That unpaid in front, these ridges are there. This is not required. You have constructed your building. Now these ridges you are putting there by blocking that 45 feet, which has been allowed to me in order dated, Your Lordship says Annex 6. The order that has been passed by the HOT officer, sub-regional officer.
Annex 6?
Yes. Sub-regional officer, what he says in Subpara 2, last 3 lines. Subpara 2, last 3 lines.
However, construction of 150 number shopping complex is comprised of...
I am not raising any grievance. Last 3 lines. Further, it is to
intimate that...
Yes, the upload of distance of 45 to 50 feet has been provided from the main road to the entrance gate, shop area of Sadhu Prasad Malik, the petitioner, for this vehicular movement and further maintenance of his personal property and shop area. My lord got it, my lord. Now, Your Lordship may now kindly come back to page, that photograph page.
Going on for which no any injurious damage is being done to the property of so and so, so and so. So this petition is purely willful and fabricated, and it is. They say that they are leaving this space.
My lord.
45 to 50 feet.
My lord.
Has been provided.
My lord. Then they are now constructing the ridges, which photograph I have shown, in front of my market complex. How do I move inside, my lord? That is the problem. The building is there. I am not objecting to it. These ridges are not required. Your Lordship has seen in Qatar, by the side of the road, now this development of ridges are being made like a footpath. This is to the private road, leading to the private road and other complexes. Here, this kind of thing, which I have shown to Your Lordship.
You want it to be left as it is.
My lord, because they are also trying to install a bust there of someone I do not know, because it is not yet placed.
Maybe your client's bust owns.
They want to kill me then, my lord. Now, this much I have a grievance. United complex they should not have done on a Gochar land, as told by my friend Mr. State Counsel.
What do you say?
Mr. Mahanti.
Question of facts, so.
What
let
is
them go to civil first.
Let's be advocate commissioner.
Not all disputed questions. Disputed questions which cannot be decided on the basis of evidentiary material on record. Otherwise, in every case you will dispute, and every case I have to send to the executive court. That is not the object. Standard books like B.L. Hansaria. He was your Chief Justice also.
I was privileged to appear for him here.
He has. See, it is not that every case involving disputed fact should be relegated to some other authority, because you will be benefited by disputing. Question is not that. Disputed facts which cannot be decided on the material on record. That is the concept. So there is some assurance saying that 45 to 50 feet we are leaving there. Therefore, he says, your representation is misconceived. That itself amounts to a kind of projecting to the petitioner. It gives a kind of estoppel that avails in his favor against you. Having said that, now if you put everything, then you have to provide him loan for getting one helicopter. So that from above he will come, he will gain entry, and he has to have his door on the roof only, because the helicopter cannot go from the front. You consider this one, you bring back your officers. It can be easily solved. Easily solved.
Your Lordship, and in fact, these regests are not required, my lord. That is what I beg to submit.
Issue emergent notice. When will you call your officer? You sit with your officer.
File counter, man.
You don't go to counter immediately. Whether counter is necessary or not, just look into. May not be necessary also. Suppose if this itself is your assurance to the citizen, then assurance given to the citizen you have to adhere to. See that Indo-Afghan Union of India versus Indo-Afghan agencies, famous judgment of Apex Court, 1960s Supreme Court. There is another judgment, some sugar mills versus Khandasari sugar mills versus so and so, which were mentioned by Palkhiwala in his affidavit before the American court in that Bhopal gas tragedy matter. When they had filed case in Indian Supreme Court, the American authority, that Union Carbide, they filed objection, saying that Indian courts are not that capable. Therefore, matter should be handled by American court. They had taken that contention before a district court in New York. Then the Union of India got an affidavit filed by two eminent jurists. One is Palkhiwala, another is J.B. Dadachanchi. In their affidavit, they said, Indian judiciary is a very strong judiciary. And one instance they gave is that the Khandasari sugar mills versus so-and-so Union of India, where the estoppel, promissory estoppel, is available as a sword, not only as a shield, in highlighting Indian judiciary. There is one famous book by Dr. Upendra Bakshi. The book's name is Mass Disaster and Law, published by Indian Law Institute, where he has produced two affidavits of one Palkhiwala, another of J.B. Dadachanchi. So the greatness of Indian judiciary is when state says something, it is bound by that. They have referred to, there are judgments to this effect, like that B.S. Minas versus Statistical Institute, where they refer to American judge Felix Frankfurter's version. If you hold something to the citizen that you are going to do like this, you are bound by that. The promissory estoppel. Okay? So look into and come back.
Take instruction.
Take instruction. You take instruction. Though matter involves urgency, a short accommodation is accorded to the learned ASC to have conference with his clients and come back with the instructions. First, call this matter on 21st. 21st.
21st.
This side.
Sorry.
This side, not that 21st.
25th.
25th. 25th. I am likely to be away. 25th.
It will be on 22nd then.
22nd. He wants
26.
Anyway, there will be somebody. Not that I am inevitable to your.
No, it is not that way. Your Lordship has considered it. It is not that way. I'll never say that. Basically, I have played for a protection.
We'll have it on 22nd.
I have played for a protection in meanwhile. Otherwise, my lord, but it has been horrible yesterday. Today morning he called me. Only status quo I am praying for. The road. Only your Lordship may indicate the road.
Let us see.
I'll be nowhere, my lord.
No, wait. Because what is going to happen?
It's only they are already blocked. I'll not have any access at all. I'm only praying for the road. Your Lordship may not say anything about the structure. I have confined my prayer only to the road, my lord. If your Lordship doesn't
till the next date of hearing, the ingress and egress to the house of the petitioner shall not be blocked by the answering respondents.
Much obliged.
But we will not stop construction.
No, construction.
Ingress, ingress, egress.
Why is it development?
Development there, perhaps with vehicle, we can understand that. And they have said 45, 50 feet. Therefore, I am saying the ingress and egress of the petitioner to the subject house shall not be shall not be disturbed. Okay. Ardent copy, man.
19 my friend has requested for a passover.
Then, sir, can we have this? Because you are already now in the model. We'll have this matter in the second week of.
Absolutely. I'm so grateful.
Call this matter the second week of September. Same one.
No, 19. 19.
Yes, sir.
19 when I am the petitioner is a school teacher transferred from his place to 600 distance.
600 kilometers.
400 distance.
400.
And his wife also.
Is it little more?
His wife is
little more. You have from 600 to 400.
No, exactly 400.
And
how
his wife has put in service?
In 3 years in this place.
Only 3 years?
Only 3 years.
Where have you stated in the petition? Show one line.
In this place from 2019.
So 6 years.
6 years. And also working the same block.
Working in the same block.
In the guideline is there on answer 4
that spousal protection. How many teachers are there?
For 3, he is on working on CRCC. On CRCC, he is also in CRCC. So,
he is working CSC.
CRCC.
Means
some 14 schools are coming under his, so take care of schools.
Heard Learned Counsel Shri. Tell your name. You are
Soumya Ranjan
Swain. So, who by his effective submission made out a case for issuance of emergent notice and grant of interim relief. First one, issue emergent notice. First one, learned ASC is requested to accept notice for the respondents. First one, stay of interim order, stay of impugned order, coupled with the direction to continue the petitioner in the very same school till next date of hearing. First one. Call this matter in the second week of September 2025.
Okay.
Yeah.
Copy in course of the day.
Same post.
Item 20.
Millards, on behalf of Mr. D. N. Rath, I pray for an Passover.
Passover?
Yes, Millards.
All right.
After lunch, Millards.
After lunch?
Yes.
If
Let it come tomorrow.
Millards.
let us see, we don't have any other matter also. Short list I have today because I was in division bench.
Item 21.
Grateful, Millards.
Here, petition challenge the transfer adjournment.
Transfer of
Bapuji Government High School to Banki Bushwa High School.
how many kilometers?
8/8/23, my lord, I am appointed.
8/8/23.
23.
So your retention period is
1 month,
year.
1 year? No. 8/8/23.
No, that's not right. Your retention period is 6 years in one school.
No, my lord. I am regularly appointed. Annexure 2, my lord.
When were you appointed? No, before that, on contract basis, how many years you were there?
Contract when I take up class. I'm taken class in the
Since how many years?
regular teacher. My appointment 8/8/23.
That's all right. You said it twice now. You have to answer board's question. When did you gain entry to the job?
2005, my lord.
2005.
5.
You have been there since 2005.
My lord.
Then that 20 years you have been there.
No, this school, different school.
Different school. In which? In this school?
In this school, in 8/8/23, my lord. You also can see annexure 2, my lord.
8/8/23 you came here.
My lord.
Where is that?
Yes, lordship. Can see page. My lord.
Annexure 1.
Page 16, man. Page 16.
Annexure 1, page 16.
Annexure 1. Sita
Page 16. Sitagan Samal, serial number 14, man. Annexure 8/8/23. 1 year.
8/8/23. Where is that written, brother?
You know, annexure serial 14, my lord.
14, I have seen that. Where is the date written?
The date of order, you know,
that itself is the date.
Well,
Okay.
8/8/23.
You are right.
Total group of teachers has been regularly appointed.
Okay.
Among of them, my petitioner was Shitigan Samal.
Any senior teacher is retained in the same school?
No, I am not senior. Senior is the other school. Other person is a senior. I am not senior.
You are not senior.
No, man.
But you are single. Though you are junior, you want to be shunted out to
I am
some other.
junior, and the question is my deficit of teacher, man. Because of deficit, man.
What is the PPT? How many
You
students?
can see annexure 4. Annexure 4. Because of deficit of teacher, managing committee given a representation. Because of considering the representation, deficit of teacher 1/7/25, one teacher has been appointed for taking class.
How
Even
many
though,
students?
Madam,
How many students?
101, madam, student.
For 101 students, there is only one teacher.
The two teachers.
Two teachers.
Two, sorry, including me.
Now you are saying
Including me, madam. If you are transfer,
only one teacher.
one teacher.
एक अध्यापक शाला.
Equation is 35, madam. Equation is 35.
1:35.
Madam.
Brother will say that
165
other students
kilometers.
will be put to whom you are going to replace him with. For 101 students, if there is only one teacher, how he will be able to manage the students? See, education
Somebody
is
might have
very,
been transferred
very-
to his placement.
No, that's all right. The question is, education is very, very important for any country. And whatever education you give to the children, that way the country will develop. If you give good education to the children, your state will develop. Many engineers will come, many great judges will come, many great lawyers will come, chartered accountants will come, industrialists come, business people come, innovations in agriculture, business, industry. If there is only one teacher, how is it possible?
I'll take instruction if there is one teacher or more.
No, I do not understand. Many cases are coming before.
No.
I am just collecting the data, statistical data. in all these cases where, see, I should not say that, Amartya Sen and John Drake, they wrote one famous book, Golden Opportunity. Co-authored book it is. He has given the comparative educational levels of various countries. Where quality education is given, those countries have come up. Where substandard education is given, those countries have gone down. Because the future of the country depends upon the knowledge of the children. Therefore, Tagore sang, where the knowledge is free. Therefore, no taxes to the universities, colleges, etc. Is it not? You have too many hands in government offices, too less hands in the schools. It should be reverse actually. For 101 students, only one teacher. What he should do? How can the children be taught? How many students will sit in one classroom?
35, Malad.
35.
Total student 101. Equation ratio is 35 to 1 teacher.
This is a horrible state of educational institutions.
Well, I have to take instruction. The
guidelines.
According to his submission, it is one teacher only. In the ground reality,
I have seen other cases also.
take instruction.
Number of cases.
Last 1 month, at least last 3 weeks, I am treating transfer matters. I am just observing the papers.
The guideline is purpose is that only surplus teacher will understand in deficit teacher. It's that purpose.
Issue. You give a
Representation is pending. Ma'am.
1 second. Let it pend. No problem. I will make an order on that. That's another thing. You furnish to us how many schools in your state. Okay. And what is the PPT ratio? You should furnish. And whether there is any vacancy. If so, what action is taken by the government for filling the vacancy? Entire material I need. I have to do something for this state where I'm eating my lunch, dinner, and I'm treated with so much affection by all of you. I should do something before I demit my office within less than a year. Okay? This is a case involving transfer of a teacher from one school to another, arguably before the expiry of the retention period, if reckoned from 8/8/2023, in terms of extant transfer guidelines. First, this case this court has been flooded with cases of similar nature, wherein very often it is contended with the prima facie material that in almost in many schools, the PPT ratio is not maintained. And that would affect the quality of instruction and teaching enormously. First off, the PPT ratio is fixed under the new education policy evolved by the central government. And after keeping in view a host of factors, in as much as the future of the nation depends upon the quality of education given to the growing children. So, first off, this aspect is discussed by John Drake and Amartya Sen in their famous book, golden opportunity, something it is missed. Can anybody take out from our Google, which is that book? John Drake and Amartya Sen. It is like golden opportunity, lost or something like that. Just look into that. First. Next paragraph. A writ court cannot turn a Nelson's eye to the apparent efficiencies in the administration, especially when right to education itself is held to be part of Article 21 by the apex court in a category of decisions. First, therefore, a bit unusual approach in this matter is taken by this court. What? First up, next up, in the above circumstances, the respondents are directed to furnish to this court the PPT ratio, pupil-teacher ratio, which is that book.
This is the Amartya Sen and Gentry's omnibus, compromising poverty and feminism.
No, not that. That is the golden opportunity.
Yes, golden opportunity.
How
is golden?
Huh?
Golden opportunity, but this is written here, and in the economic development and social opportunity.
Social opportunity. Can I that golden opportunity? Just no, I got that. Yes, I read that book about 5-6 years ago. So one of the best books. I referred in some of my judgments also. In the above circumstances, respondents are directed to furnish the PPT ratio in all the schools in the state as existing on 1/8/2025, specifically mentioning the existing vacancies and the steps that are being taken to fill the same up. First off, next paragraph. In the meanwhile, the impute transfer is stayed.
Annexure 3, man.
Stayed. And the petitioner is permitted to continue in the same school in which he has been serving till date. Brother, I will fix this date. You have to furnish full particulars. How many schools? What is the teacher-student ratio? What is the vacancy position? How you are going to fill the vacancies? By that, you will be making great service to the state. Really. Okay?
Notice is issued.
A notice is issued. Okay. I'll call this matter along with WP, which is that similar matters are there now?
Item 16.
Item number?
16.
16. 16.
Item 22.
May I please, May I please, Milord?
Yes.
Matter relates to replacement of one set of contractual faculty with another set, which is not permitted. My lord, 2 interim orders were passed by this court, one on 11/7/2025, wherein this court
Heard learned counsel Sri so-and-so appealing for the petitioner, issue emergent notice and interim order as brief for in the
My lord, interim orders have already been granted. First interim order, this court directed
this matter only.
This matter only, my lord.
Now interim order is there.
Yes, my lord. 2 interim orders are there.
Saying
First interim order that is dated 11/7/2025.
go to 11/7. Some other matter or in this case?
22, my lord.
Huh? 11/7/25. Where is the special quoting for the period of There is no interim order as such, only seek instructions. Then,
My lord,
the next
second-
state of the
second
you are right.
page.
May
My lord-
continue, but the post mentioned that shall not be filled up without it. Then we'll say.
My lord, a second interim order was passed on 29th of the previous month, wherein the petitioner was permitted to continue. My lord, these two orders were communicated to the opposite parties. They are not allowing me to continue, and now they have issued another advertisement for the same post, my lord. That is there at Annexure 14. I have filed an IA at flag C, my lord. Annexure 14, page 11 of that IA.
Right now. Why, brother? He has taken notice.
It's for university, there is own panel.
University.
Yes.
University has done this.
My lord, college, that is Government College of Engineering, Keonjhar.
It's a government college.
Yes.
There is an order.
That I'll take it.
Two orders are there. You can take instructions. I may direct the presence of the chief secretary. I will summon him here. Why this is happening? Why court orders are not being obeyed?
Yes, I'll take it.
No, that is a serious matter.
My lord, the
Learned counsel for the petitioner has moved an application wherein he complains that two of the interim orders made by this court, respectively on
11/7/2025
11/7/2025 and
29/7/2025
29/7/2025 have not been complied with, and therefore some action, punitive action needs to be taken against the violators. First up, learned AGA seeks time to confer with his clients and come with his officials and come back with instructions. First up, call this matter on 13/8 with the warning to the concerned officials that should version of the petitioner be true, some bad action will befall on them. Some stringent action shall befall on them. Okay, what's the prayer in this application?
My lord, to stay the advertisement.
Next paragraph. But one post will keep vacant.
My lord,
Why advertisement? That order is there, no?
That order is there. In violation of that order, they have issued this notice.
But what notice they have issued?
A new advertisement they have issued.
Correct. Where is that interdict? That is not prevented. Only one post to be kept.
My lord, but that post has been also advertised here.
Advertised, it does not mean keep one post vacant does not mean don't advertise at all. They will advertise. Suppose 100 vacancies. 99 vacancies they will fill up. One post they will fill up. Is it not?
They have not indicated the number of vacancies. That is the difficulty, my lord.
They have not indicated?
No, my lord.
All right. Call this matter on 19/8.
My lord, I have also filed a contempt today. I have the diary contempt number. I have also.
Where is the contempt? It's not posted today.
My lord. My submission is that this may come along with that, this contempt application.
It's a separate case, na? All right. Call this matter along with
I'll supply the number, my lord.
Give that.
Okay.
Court orders compliance is a must.
Actually, the copy of the order will
we were posting it, web copy to be acted upon. You will download and act upon. See, in all orders, whether final judgments or interim orders, put that sentence. They need not apply for certified copy at all. They should reach their home wherever they want. Yes.
Item 23.
May I please, Your Lordship, in pursuance of the order of this honorable court, I have filed.
Government which does not honor the court order is very bad. In fact, when Mahatma Gandhi had called for civil disobedience, Winston Churchill, as the Prime Minister of England, wrote a letter to Mahatma saying, Mahatma, you are laying wrong lessons before your people, countrymen. Tomorrow, if we quit, how are you going to govern the country? So ask them to obey law. That's how it is. See, Dasharatha said to Rama, go to forest. And mantris advised Rama, don't follow what your father is telling. He is uxorious. He is very much after Kaikeyi. And Rama said, I have to follow the order of my father for two reasons. Number one, he is Maharaja and he is personification of the government, state. Therefore, as a citizen, I have to go to forest. He is my, otherwise, other children, other citizens will not follow. The second reason is, he is my father. Therefore, I have to obey his orders. Pitru, how Valmiki in Ramayana says, Pitru Vakya Paripalanartha. Therefore, court order Paripalanartha. You have to follow the court orders. Or you can challenge that order. Our orders are not infallible. They are vulnerable laws. Get them stayed. But as long as the order remains, so long, you have to comply with the order. No concession in that. I will levy a very deep cut in an appropriate matter. I have been seeing many matters where government is taking a stand which is an affront to the judicial process. That we will not tolerate. Yes.
Yes, the petitioners, the retired teachers, the pension has been reduced after 11 years of retirement. So there was some mistake which I have filed amendments, 4 amendments of which I have filed. That has to allow the.
What amendment you wanted?
Wherever there is demand for recovery, it should be initiate recovery of the alleged excess amount. Because the previous means observed, there is no, let's say Annexure 4.
Why are you disturbing? This is a court hall, the temple. Be silent. Yes.
The input order at Annexure 6 said, input order at Annexure 6, Your Lordship,
you have made application for amendment.
Only one amendment. That will not change the nature and character of the case. Amendment is Annexure 4, page 35. Wherever it says there is the previous man's point, there is no demand. There was only initiation of recovery. So that part I have changed.
Application is no notice was issued.
No notice was issued.
An application at pre-notice stage, supported by an affidavit, seeks leave of the court to effect a short amendment to the pleadings, which are structured on the premise that recovery has already been done when it is only initiated. First, such amendments need to be allowed, since no prejudice should be caused to anyone, except that the pleadings become little longer. First, denial of leave to amend would cause injustice, may cause injustice to the petitioner at this stage. First, in the above circumstances, application having been favored, leave is accorded to carry out amendment within 1 week.
I have already got the consolidated petitions.
Yes, you have done that. Leave is accorded to effect amendment at the earliest. First time. You have to amend here, then amended petition you have to file.
Yes, I have.
Amendment of pleadings, filing of amended pleadings. Both are
that consolidated petition I have made ready.
You have done that. But here you have to, in the original you have to make some amendment.
Yes,
with the
there is one Lordship,
saying white court order dated so and so.
Probably Lordship could not cut. There was a demand for recovery. There is no recovery.
Took that.
No recovery was not already made. It was demand for recovery.
Initiation, you have used the word initiation.
In place of demand, there is initiation.
You are doing that. But that amendment you have to carry out in your ink, with your ink, as per the rules, as per the decision.
I'll do it now.
Just do that and file amended petition also. Give that paper. Petitioner, with leave of the court, has endorsed the amendment. Endorsed the amendment in the original proceedings, original papers, and he has filed amended petitions as well. Same to be taken on record. Just make a note that. Okay.
Yes. Can it be date be fixed because the teachers retired since
issue notice? Will issue notice?
Millets. Because there is the pension has already been reduced and there is demand for there is initiation for recovery.
They have recovered now? No.
No, initiation for recovery subject to waiver. Subject to waiver.
So when they retire?
Retired in 13-12 onwards. They retired. It's also Sainik school. The state is not
recover anything now.
Not state Sainik school teachers
issue emergent notice. That AG is requested to accept notice for.
No, it's not. State is not a party.
It's not a party.
Sainik school.
Okay. Issue emergent notice. Sainik school is a Article 12 entity.
Yes, there is a society.
Issue emergent
educational institution.
First off, in addition to taking usual steps, petitioner is permitted to serve copies on the panel council if any.
I'll take notice by register.
I have said by register. Registered post is still there or speed post now? Speed post, na? Registered post is
either registered or states because there
is abolished in the country.
No, there is a amendment. There. No, I don't know. There was some.
Registered post, speed post.
Speed post. You are asking speed post.
In the meanwhile, the impugned order. How many orders?
Orders at Annexure 6.
At Annexure C.
6
series, huh?
6 is 6.
Series? 6 series or state.
No, only 6. The
Annexure 6 is state. In the connected petitions also.
Connectors all in 6, what except in only in a 19079. It is Annexure 5.
All right, see that. You can say like this. No recovery shall be made from the pension till next date of hearing in all these matters. Okay. And the third week of October.
Yes, they have already made the refixation. Can it be they have refixed the pension?
We have said no recovery should be made. But refixation, it will happen. Recovery is stopped. But you will get reduced pension because of refixation. Okay. However, a refixed pension shall be payable subject to outcome of the petitions.
Co-placements.
Yes.
Item 24.
May it please your lordship, I have filed a memo for withdrawal of the petition.
Why are you unhappy with the court?
My lord, today I am somewhat physically.
No, that's not. Why you want to withdraw? Just we know the reason.
Yes, my lord, because some development has happened. The representation by Annex 4 and 5, which I had given to BMC, that has been rejected by an order. So I want to incorporate those things, my lord.
Petition, counsel for the petitioner submits, has become infructuous, orders on the subject representations having been passed. First, counsel seeks leave of the court to withdraw the petition with liberty to challenge the orders now made on the subject representation. Leave is accorded and the petition is disposed of as having been withdrawn with liberty as sought for.
Obliged, your
25.
My lord, in this case, I have challenged the order passed by the Commissioner cum Secretary, School and Mass Education by Annexure 8.
Annexure 8?
Yes, my lord.
What is that?
Before going to Annexure 8, my lord, this is the second round of litigation. So I want to place the earlier order passed by this Honorable Court. So your lordship will be clear. Page 24, my lord. What was the case? Why I had come? Page 24, my lord. Order number 2, dated 7/5/14, my lord, 2014.
Do you have objection if I believe you?
My lord.
If I believe you, do you have objection?
No.
No objection. Then can you tell what was that?
My lord. My lord, the petitioners were working as non-formal facilitators. The non-formal, your lordship may kindly see page 24, paragraph 2. Page 24, paragraph 2.
Working as
non-formal, working as NFE instructor under the government of Orissa, filed this
what
application.
What is meant by NFE?
My lord, that teacher scheme. They are teachers, my lord.
Okay.
Non-formal facilitators, my lord.
Okay.
The government of Orissa filed this application seeking for a direction to consider grievance for absorption in category of Gana Shikshak in accordance with the guidelines issued by the authorities.
Consider the representative.
My lord.
Next, what happened?
Then, my lord, they have rejected my application. Your lordship may kindly see the entire order is most important because your lordship may kindly come to page 25, the next page.
25.
Yes. Considering the contention raised by the parties and after perusing the records, it is admitted fact that earlier the petitioners were engaged under non-formal education scheme introduced by the government of Orissa, and he had discharged his duty under the said scheme. The said scheme has been abolished in the year 2001. Subsequently, EGS scheme was introduced, and as per the guidelines, the case of the petitioner had not been taken into consideration, and the said scheme was also abolished, and the government has decided to rehabilitate those education volunteers as Gana Shikshak under Sarva Shiksha Abhijan, but the reasons for discrimination of the petitioners have not been indicated anywhere. If the government has formulated such guidelines and priority is to be given to those who have gained experience, like my lord, the present petitioner, experience, they should be absorbed under the new scheme. Without doing so, the petitioners have been discriminated. In view of such position,
so consider the representation.
Yes. Thereafter, my lord, they have rejected my then Annexure 7, page 27 is my representation along with the order copy of this Honorable Court. Thereafter, my lord, the order of rejection. My lord, what my commissioner has done, your lordship may kindly see the front page of the order. Front page of the order, page 29. Commissioner should consider my case specifically. But what she has done, my lord, 15 cases altogether. Some people are working as education volunteers. They are included that they have disposed it in 2-3 paragraphs orders. She has not at all applied her mind, my lord. Mechanically, she has rejected my prayer because I have worked for more than 10 years as a teacher with a hope and aspiration that a day will come when I will get some benefit, my lord. After putting 10 years of service, you will retain me. My case is that new scheme has come after abolition of NFE scheme, and this Honorable Court has given a direction that you consider each case. Consider means not you reject her case. Because he has a case on merit, he will make another fresh representation with the copy of this order. You consider. She has not considered my case. She has considered 15 cases. Your lordship may kindly see. 1, Kamal Lochan Acharya. 2, Urvashi Sahu. 3, Meena Behera. All cases are not same, my lord. In most of the cases, I am the lawyer. I have conducted. So let my lord can take instruction what they have done, at least in my case. Because the notice has been issued. Since, my lord, 2015, no counter has yet been filed.
We'll take the petition with face value. After 11 years, we will not permit filing of objections.
It will chance out the last chance you will actually.
What chance? 11 years. You think that perhaps your government thinks that this is a state where all citizens are slaves. They are not slaves.
16 onwards.
They have every right to come to this court and complain against the government.
2016 onwards, the matter has not.
Why it should come? You have issued a notice is received. Matter has not come means the fault lies with the courts. Why he should suffer for the fault of the court, which prevented you from filing the objections? Perhaps your government thinks all citizens are slaves. Therefore, we need not obey court order. We need not file objections. It is your prerogative to file objections. We cannot direct. We have not filed one. Therefore, we will take this petition with face value and grant relief so that government will learn the lesson.
I pray last chance you may give some.
No, I will give you, but 11 years have lapsed. For 11 years, the prime part of the life of these persons has gone waste. Can we get it back? T.S. Eliot says, where is the life we have lost in living? By living, we lose our life. That happens to everybody. But why they should spend their 11 valuable years in the bad place? Court is not a happy court, happy place to come. Nobody will come to court with joy in heart. Everybody comes to court with court. With no joy in court, people come to court. No joy in heart. We can't deny relief to people by quoting some theories. Who will come to court with happiness, tell me? It is not a clubhouse. Inevitably, they come to court. Absolutely, reluctantly, they come to court. And to them, if we deny relief, where they should go, then they have to spend the money, put it into the pocket of the officers. You are our God. This is our dakshina. Do our job. What will happen to the judicial process? For 11 years have lapsed. We'll impose 22,000 rupees, 2,000 rupees per year for wasting life of the man. It is very nominal. But anyway, you pay 22,000 rupees.
Lordship may allow me to take instruction.
I will allow you.
Your Lordship may impose cost. Let me take instruction. Why this?
No, you take instruction. For that, I give you time, yes, subject to paying 22,000.
Let me take the instruction.
No, for that, court does not need your instruction. Court has power. Constitution gives power to us. We do not work at the mercy of the government.
I am not in a position to say why this for 11 years.
Therefore,
so only I pray.
We do not know. 11 years have lapsed. Unless something is done, your government will not wake up. I know. Government, we were taught in the administrative law, government is the first enemy of the citizen. First enemy of the citizen. Whereas our scriptures, our Vedas, they said, Raja Pratyaksha Devataha. Raja is equivalent to Deva. Therefore, in English law, till 1947, Crown Proceedings Act was passed in English law. The law was king can do no wrong.
That was in Satya Yuga. Now it is Kali Yuga.
We know how to wake up your government. We have some instruments with us. Right now. Petitioner's prayer is as done. First time. This petition was filed on 2/12/2014. 24/11/2014. And go to first order, issuing notice, etc. When the order was made. Order number 2 dated 9th of February 2015. A coordinate bench of this court, while the order dated 9/2/2015, had said as and done. First time. Thereafter, the file was stacked in the cupboard of the court with not even a single ray of sun falling on that. First time. Till date, no counter has been filed by the respondents. First off. Of course, it is the prerogative of the litigant to file the pleadings or not. First off. But when a time is sought for filing the pleadings at this length of time, leave cannot be accorded sans costs. And such costs have to be heavy because the citizens grieving before the court have lost 21 years of their 11 years of their valuable life in the court corridors. First off, in the above circumstances.
Notice to the OP3 has written, that is the noting in the cause list.
For OP1 and 2?
1 and 2 the state.
They should have filed the statement of objections.
One is men.
But in the above circumstances, the respondent now of OP numbers 1 and 2 are saddled collectively with a cost of rupees 2,000 per year, which works out to 22,000 payable to how many petitioners?
One petitioner.
To the petitioner within 2 weeks, failing which the cost may be doubled on the next date of hearing. First off, the cost to be recovered, cost component to be recovered from the officials responsible for the lapse. First off, call the matter on 20. Call this matter on 26. In the meanwhile, objections, counters, if any, may be filed. Okay. Okay.
Just item 36, that has been adjourned.
36?
Item 36.
Some mention was made.
That has been adjourned, but so far as 3 cases are there in that in item 36. One in WPC 16242, counter has not been filed as yet. Only direction will given to file the counter.
You can take advantage of not filing counter. Don't invite counter. You want to invite best weapons for the war from the side of the enemy. Take best advantage of that.
This was adjourned to 2nd week of September.
2nd week of September. They know now what I will do when no counter is pointed.
Item 47. Since I took concern of my friend Milos, because PIL bench will be taken off at 2 p.m. Milos is separate cut up PIL bench.
You will be on the
that is what I requested my friend Milos.
This is my lord.
Serial number
27, Milos.
27.
May I pray, my lord? If it can be taken up on 12th.
12th?
Yes, my lord. Because plight of a widow lady.
So no problem.
What's this serial number?
27.
27.
My lord.
2023 matter.
Yes.
The pleadings are ready. Only government is to file, the GA department is to file an affidavit pursuant to the direction of matters.
5 days.
They have not
That we have also.
They have filed that. If they don't follow,
we have filed also.
we know what to do with them. We know that art now. Yes. On this matter on 12th, as
Item 30
at the bar unanimously.
After 30 minutes.
30.
Learned friend has filed certain documents. I have to verify.
When it will?
Any date, your lordship, any date. Next week or any date, I'm ready, but not today.
Next week. I have already filed.
Which year matter?
It is a matter of
24.
That also the case was before this court.
On 21st. Okay. On request. Matter. Okay. All right. Yes, ma'am. Okay. Yes. Lord, in this case is a checkered history, but the fact is, who is your opponent? State. State, yes. But a very small case. It was the second round. Lord, the petitioner was a teacher. He was suspended. But thereafter, no proceeding was instituted, nothing was done. I came before this Honorable Court. This Honorable Court directed them to proceed and pass an order as per the rules. They have completed the proceeding and says that around 1,63,000 is to be recovered from me. Because I was in the inquiry. Yes, there is no proper inquiry, but I do admit now the precarious condition is of 2012, we are in 2025, man. So accepted that. Question is that now the problem is, even if the punishment is imposed, and I am ready and willing, I have told them that yes, I don't have money, you please recover from my salary or whatever the dues area I am entitled to recover, but they are not allowing me to work. Whether you are found guilty? No, yes, that guilty. Was it moral? No. Involving moral turpitude. They say I was absent for a certain period in that 2012, but I have drawn the salary for that period. This is absent also. It is their allegation. Now I do admit that because of the punishment, because the person is so precarious and his position is so precarious. She do admit, but though she has filed an appeal against that order, because it doesn't want to proceed further in the appeal. You want to give up that part, 1,60,000, she will recover. That will let me recover. 1,60,000 in which year you received that money? That they are saying that period is, my lord,
2006 to 2009.
2006 to 2009.
What is instruction? 1/12/2006 to 31/12/2009.
1/12. And it on to the punishment order.
31/12/2009. Because at the same time, he was also serving in another school.
No, that is not a fact.
That is the instruction I have received.
Instruction, you have a counter here.
Yeah, who filed counter?
Yes. The punishment order, my lord, will get it at Annex 8, page 36. The final money you have received?
1,66,700.
700, that is now the order is, therefore, upon consideration of charge against Akshay Kumar Bala and upon consideration of his representation, it is ordered that the amount of rupees 1,66,700, which he has received as salary without attending the school, shall be recovered from him as prescribed under Rule 13(4) of the OCS CCA Rule 1962. This is a minor penalty. It's not that simple. You are a teacher. What kind of lessons the children will have? No, for that, you have remained absent. You have drawn the salary. Suppose if the judge remains absent and still draws salary, what confidence you will have in such a judge? I have filed an appeal against that order because that is not a fact. Now, because of his condition, my lord, I am just proposing, my lord, that let him be. But I have filed an appeal. I have said, no, it is not a fact. I was discharging my duty. I have signed the attendance letter. I have put teaching to the students. So whatever the allegation I have, my appeal is pending with the director, not that I have admitted. But because of this condition of this person, I am submitting on his behalf before this Honorable Court that even if you are saying that because there is a minor penalty now imposed upon me, so you please withdraw and allow me to work. You will not be allowed to work till appeal is decided. If you succeed in appeal, you will be allowed. Otherwise, you will be sent home. Appeal is filed. What kind of message? If a teacher is not only teacher in science and philosophy, he is a teacher on morals also. Only the morals we draw from our teachers. I do admit, my lord, if that could have been done 24/6/24, he has filed an appeal against that order. That is Annex 9 to this. Direct appeal to be disposed of. That appeal should be disposed of. Till then, he will not be permitted to be a teacher in the school.
No, he has already resigned.
This will resign also. No, that is not a.
In 2012, he has resigned.
These things are not record. Let the doubt not record. I will file my.
I will file counter.
On the face of it, it is not acceptable.
I have received
they say, I have resigned. Let us accept what he is saying. Because that is a statement they are making, they are not filing any document. But if I will see the charge sheet, if he quits the post
yes,
and goes elsewhere, You take the money along with interest.
Yes.
And be happy. So that he will have a job elsewhere. Well, these things, certain times these things happen. But he will not be allowed to be a teacher in that school. Let him go elsewhere. Are you agreeable to
No, sorry.
I'm not
I am quite silent. Because I have filed an appeal. I have my objection before that. Whatever he is saying, well, that is wrong, not on record.
No, on
It's just an instruction he is saying
instruction.
every time. No
Anyway,
complaint.
your appeal is pending.
Yes, that must be your, my lord.
Petition dismissed on the following grounds.
My lord, dismiss.
Number
My lord, sorry, my lord.
Sir, you have
Sorry, my lord. Sorry. Sorry for that interrupting, my lord.
Yes.
My lord, may not say this, we cannot dispose it of. Otherwise, it will give a bad message and the director will hurl upon him. That is the difficulty he will face. The authority will be prejudiced. No, sorry, they will preserve the issue against me. This person will be prejudiced.
If this is fine. Petitioner, a person in the teaching occupation, is knocking at the doors of the court with the following prayer. First, reproduce full. Next one. Learned counsel for the petitioner submits that the respondents are not justified in disengaging his services, especially when his appeal against the penalty order dated 25/4/2024 is being considered in the departmental appeal preferred by him, and that even otherwise he is ready and willing to remit the amount back to show his bona fide, and therefore a direction be issued to the jurisdictional opposite party to take him back to the duty, subject to outcome of the appeal. First stop. Next paragraph. Learned AGA appearing for the OPs resists the appeal, contending that during the period between 1/12/2006 and 31/12/2009, the petitioner was absent from duty, and despite absence, he has drawn the salary for the said period absolutely without any justification, and therefore the recovery order has been made, and further he has not been permitted to join the service of teaching. First one. He also submits that a teacher has a greater role than just imparting education, but also of inculcating moral values in the students, and that basic principle will be breached should there be a direction to take him back to the duty. First. Next paragraph. Having heard the learned counsel for the party and having perused the petition papers, this court is broadly in agreement with the submission of learned AGA that the petitioner should not be permitted to discharge his duties as the teacher in the subject school till after and subject to outcome of his appeal allegedly pending before the appellate authority. First off.
I beg your pardon.
He also tells the court that the petitioner has resigned the post in question
On 12/10/2012.
with effect from 12/10/2012, which is stoutly denied by the petitioner's counsel. First off, this aspect of the matter is not examined by this court, and the same is left to be considered by the appellate authority itself. First off, next paragraph. With the above observations, the petition is disposed of.
And frame a time limit for the authority to decide my appeal.
The appellate authority disposed of with a direction to the appellate authority to dispose of the subject appeal if it is still pending. But all contentions of the parties are kept open.
Within time limit, my lord, I play.
The dispute of the
Any time, my lord,
parties within a period of 3 months, if it is still pending. First, all contentions of the parties are kept open. Okay.
Item 20. Wait.
Wait, 1,66,700. That you understand? Not that you heard. Later on, salary totally in a sum of rupees 1,66,700. Yes, sir.
My petitioner was appointed as a junior clerk in the year 1996, my lord.
Junior clerk.
Clerk in the year 1996.
1996.
My lord.
Can you be specific? Date?
Date, my lord, 23rd of May, 1996.
Yes, sir.
Though petitioner transferred in different times from 1996 onwards, my lord, in 2013, 25th of November 2013, petitioner was placed as a junior clerk in the office of Block Education Officer, Kurkunda, my lord, in the district of Malkangiri.
Earlier, where he was?
In the government high school. All through from 96 up to 2013, he was posted in government high schools, my lord. Different government high schools.
Thereafter,
my lord, in 31st of December 2019, petitioner was promoted to the post of senior assistant, my lord, from junior clerk to senior assistant, and posted in the office of the, my lord, Block Education Officer, K. Guma.
Senior assistant.
My lord. My lord, again, petitioner was transferred in 2024, 3rd of January 24, from Block Education Guma to Block Education Officer Kurkunda, my lord.
No, the first transfer was with effect from which date? Because of promotion.
Promotion.
Promotion. Once you are promoted, you cannot.
I am not disputing that.
Yeah.
What has happened in last promotion was given on 3rd of January 24, and petition was posted in BEO Kurkunda.
3rd of January
2024.
24. That 31/12/2019. After that promotion, you were posted to which place?
Posted to my lord, Block Education of K. Guma.
Guma.
K. Guma. G-U-M-A. K. Guma.
K means
K. Dot K. That is
it's name of the place.
Kumar Guma.
Kumar Guma.
My lord, that is that. I will get it page 28. Kurumla Guma.
Anyway, you only are now not able to pronounce, but therefore I cannot pronounce it at all, even if you teach him. I will take that way. No issue. Then 31/2024, he is posted to?
That is posted to be from K. Guma to he is transferred to BO Kurkunda, where he was earlier.
BO Kurkunda.
My lord.
Spelling? KURKUNDA.
My lord.
Early one is what? Guma?
Start spelling, my lord.
No, just you tell me what.
K. Guma. KUDUMULUGUMA. I am not on that, my lord. My only grievance, my lord, on Annexure 7, on 30th of June, my lord, 2025, there are two promotion orders passed. Two promotion orders to the post of section officer.
You are further
promoted.
You are further promoted on
30th of June, 2025.
25. As section officer?
My lord, section officer. As per the gradation list, though I am serial number 1 in the gradation list, and serial number 2, there are 1 and 2 both are promoted on 30th of June, my lord.
Same day?
Same day, my lord.
Who is senior in age?
I am senior, my lord.
In age?
My lord, in both.
Which rule provides for how? In Karnataka, rule is where two persons are promoted on the same day, they will have the seniority based upon their age.
My date of birth.
Such a rule is there? Okay.
My lord,
I'm not.
Who is senior to him?
I am not disputing with seniority.
This is subject to one. Where a particular two persons, if one is senior to him in the lower cadre, he himself becomes senior.
My lord. My only limited grievance, my lord, on 30th of June, 2 persons were promoted. That another person was promoted to the post of section officer and posted in the office of BEO Kurkunda, where I am continuing as a senior assistant. Where I am continuing as a senior assistant, that in that office, section officer post was lying vacant.
To that office he was posted.
He was posted. And
you were posted to Kurkunda.
And I was posted to Block Education of Kalimela.
Yes, tell the spelling now.
Kalimela. Page 34, my lord, kindly see for a moment.
Kalimela. Is it anything to do with goddess Kali? No, nothing like that.
Then one of the longest route of Odisha.
Okay. So you were posted to Kalimela.
My only and on the next day, 1st of July, that person who was posted in
along with you,
with me in my office where I was earlier, B.A. Kurkunda, he retired.
Very next day he retired.
I made a representation
to post you there.
Since that post was vacant and a distance place, I may be accommodated on the ground of my wife's some surgery is there and children are reading and Annexure 10, all the representation and medical documents are there.
No, 1 second. On 36-25 second promotion you earned. And you were posted to Kalimela. And then what happened?
But on next day, that person was posted in the office of BEO Kurkunda as a section officer. He retired.
But as a section officer?
He retired.
Therefore, you wanted to go back there.
Therefore, next day, I filed an application. Since he retired, post of section officer lying vacant.
How many years you were there in that place?
I was just, I came to Kurkunda. I came to Kurkunda on my 3rd of January 24.
Yes.
So my application, without considering the past Annexure 9, you go, otherwise the proceeding will be initiated.
You did not join the...
I have not joined, my lord.
Then that's a misconduct.
But I am on the ground medical because of, I have given the application, my lord. That's true, my lord.
Join there and then we will direct them to reconsider your representation. You go and join.
Within space, a short time, so...
Brother, if he joins there, then you reconsider.
Yes,
reporting for duty. Showing bona fide. Because what is the difficulty in that office? Why you should be sent back to another office? There is a matter of discretion of the employer. The High Court cannot run a race of opinion with the executive in matters like
within 2 days, my lord, I will join, my lord, and let them take a decision.
Take now. Petitioner gained entry to the public service as junior clerk with effect from 23/5/96. And he was working in government high schools, in various government high schools from time to time. First time. He earned his first promotion to the post of senior assistant with effect from 31/12/2019 and was posted to work in the office of BEO at Keguma. At Keguma. First up. Second promotion to the post of section officer he earned with effect from 30 June 2025 and was posted to one more sentence. He earned first promotion as so and so was posted to first time. He earned a second promotion. It's not second promotion actually. You were posted to the office of BEO Karakunda with effect from 3/1/2024.
The second promotion to the section officer.
So that is
30th of June.
6/20. But before that you were in Karakunda.
Kurkunda, I was returned back. I was returned back from Keguma.
All right. First promotion, so and so, and he was posted to work in the office of BEO Keguma. Thereafter, he was transferred to the office of BEO Kurkunda with effect from 3/1/2024. First time. Next paragraph. Krishna earned the second promotion as section officer with effect from 30 June 2025 and as a consequence came to be posted to the office of BEO Kalimela, where the Kalimela, first time. On the very next day, the post of section officer in the office of BEO Kurkunda became vacant on the superannuation of the incumbent. And therefore, he made a representation to post him to that vacancy to mitigate hardship. What was the ground? Why you wanted that place? A very attractive place.
The ground that petitioner's wife was undergone surgery of the cancer and the students are reading.
Oh, cancer patient.
Page 35.
I'm asking you. What is the stage of the cancer? What is the nature of cancer?
Sorry, I'm so extreme sorry. Petitioner undergo surgery of cardiac operation. Cardiac operation.
Cardiac operation. On the ground of
some hospital.
On the ground of. He only had undergone cardiac operation.
Petitioner's wife.
On the ground that his spouse had undergone cardiac operation. What is the nature of the operation?
That does not.
Cardiac operation has got many types.
That does not indicate. As recently undergo a major cardiac operation at some hospital, Bhubaneswar, and is advised to take rest and medical checkup. My daughters and son are studying in class 3 and class 8, respectively. In
that he had school-going children. They were residing in Kurkunda.
They are Kurkunda.
At Kurkunda. First of all. The third representation having not been considered, he is grieving before the writ court. First of all. Next paragraph. Learned ASC appearing for the official respondents resists the petition, contending that no public servant is immune from transfer, semicolon. It is the duty of every public servant to report to duty wherever he is posted by the executive in its discretion. Semicolon. A host of factors enter the fray of deployment of the public servants, and those factors are not judicially manageable, judicially accessible, and therefore petitioner, having not joined the place to which he has been transferred all these days, cannot be shown any leniency by this court. First of all, he relies upon the decision of the apex court in Varadha. It is not Varadha Rao, V-A-R-A-D-H-A, Varadha Rao versus State of Karnataka. A.R. Societies. Next paragraph. Having heard the learned counsel for the parties and having perused the petition papers, this court is inclined to grant a limited and conditional indulgence in the matter, although broadly agreeing with the submission of learned ASC, that every public servant is liable to be transferred unless the rule provides for the contrary, and in this case there is no such contra rule, and therefore petitioner has to go and report at BO office Kalimela. First off, learned counsel for the petitioner assures the court that he is going to do that within 1 week. First off. Next paragraph. One sentence. This is consistent with what is observed by the apex court in Varadha Rao. First off. Next paragraph. Learned AGA is to some extent justified in telling the court that an employee who remains absent for a long time only because his representation for a transfer stroke posting is pending cannot be shown leniency. First of all, as a broad proposition, it may be arguably true. First off. However, the government being the model employer in the light of apex court decision in Bhupendranath Hazarika versus State of Assam, it cannot treat an ailing employee with cancer or with cardiac ailing employee or his spouse, ailing employee, or the spouse ailing, that is suffering from cardiac disease, and children studying in schools, little children studying in schools. First off. Shukraniti says, the king will antagonize his servants if he treats them with no dignity and with no human value. First of all, this Justice Ramajai quotes in his Services Under the State magnum opus. First of all, therefore, it is not a fit case where any penal action should be taken against the petitioner for not reporting for duty at Kalimela, pursuant to his promotion order dated 30/6/2025. First off. However, he need not be given salary for the said period on the principle of dies non. Dies, D-I-E-S, non, separate words, italics, dies non. First one. Next paragraph. The above being said, the representation of the petitioner could not have been kept pending eternally on the table of jurisdictional officials. First one, in Varadarao, it is observed that when an employee gives a representation against the transfer, a post-haste decision has to be made thereon, provided that he shows bona fide and punctuality in service by reporting duty at the transferred place. First off. Next paragraph. In the above circumstances, this petition, in the above circumstances and with the above observations, this petition is disposed of. First off. Time for disposing of petitioner's representation dated
30th/6 onwards, my lord. 10 series, I believe.
Dated 30/6/2025 at Annexure.
Annexure 10, my lord, page 35.
10 series is 6 weeks.
No, already his representation has been disposed of.
Unless it is already disposed of.
Not disposed of, my lord.
Your lordship
We are saying
kindly...
pending, if he is disposed of, we have to challenge that. Yes. We have said unless it is already disposed of. First off. Next paragraph. First off, all contentions in that regard are kept open. Next paragraph. Open to the answering respondents to solicit any information or document from the side of the petitioner. So and so. Web copy to be acted upon. In all judgments and orders, put this sentence. The government should act upon the web copy. We are moving towards the web world now. Yes. Pleadings are filed, e-court, and hard copies are insisted of.
Item 26.
In this case, the petitioner challenged the disengagement order. She was engaged as Shiksha Swahaka, duly selected and engaged. Thereafter, the authorities found that her marks not coming under the cut-off mark. Thereafter, they have rejected and disengaged me. And just now, I have received the counter copy.
Just now, you have received?
My lord.
This petition is of 2016.
My lord.
You have filed the counter now?
Though counter has been filed
when it was
much earlier, But
21, 23.
Since 23 million.
20th January.
But my learned friend has not received the same.
Anyway, they have filed it
I
after
have served the
9 years. Brother Mohanty, you have filed it after 9 years, but our rules do not permit the filing of counter after 9 years. If you pay some money, we will take it.
Since 23 it has been filed.
23. Even then, how many years? 7 years. 7 years is a too long a period in man's life. 7 into 2 will be 14,000. There 11 into 2, we made it 22,000. Another matter.
I go down, my lord. But fact remains, there it has been filed already, my lord.
Why you have not filed? Our court would have posted the matter if you had filed the counter earlier.
But it has not been.
So many years are lost in keeping the matters pending. What the confidence of the people in the judicial process? They will go for alternative bribing officers, etc., to get the work than to die in the court.
On perusal of the order sheet also, it is found that it was last entered on 18/6/2016, Milo.
You should have filed then.
Thereafter, in fact, this is.
No, it should be posted unless you file the counter at all.
Counter is since 23, they have filed.
Pay 2,000 rupees per year.
January 23.
If you want us to take the same on record, your filing is not equivalent to placing on record. If it is placed on record, but it has to be taken on record by the court, that court will do, provided it is filed in time.
This time I may be exempted because it has been filed already.
That's already filed, but 7 years are over. It cannot go there.
Kindly appreciate this. And though counter has been filed, whenever it is not being filed, I concede to that extent that it is a.
No, that's not.
Laches on the part of
government
the
has to be a model litigant.
Henceforth, if at all it will not be filed, then this can be about 23, 2 years back already filed. 2.5 years back.
You give one set of books to association library. All right. Which book you will give?
Milords advise me, whatever books.
There is one book by Chitti on Contract. Its price is 28,000 rupees.
It will be much more hard than what your lordship is.
You can ask. You can ask your office to give that book so that they will not. At least library will be rich. Somebody will go. Somebody will read. Some palkiwala will emerge from Katak in the course of time.
No, will supply the book absolutely, but it is too costly. Single book will be given because I will be in trouble because since 23, as the counter has been filed.
No, you have filed the counter.
Yes, my lord. January 2023.
You become government advocate in which?
No, I'm recently, my lord.
Therefore,
6 months back.
Be with them. Why do you worry?
No, I don't want to shift the button to anyone. But this is a factual aspect. It is my duty to. This time I may be exonerated. If the counter is not filed.
All right, understood.
No, any book is there.
You give
for the welfare of the lawyers. There should not be any agitation.
That's a good gesture. You give.
My lord, that Godabaram book, my lord, such in other day said. In fact, that publisher neither it is available in the book nor it is in a.
Yes.
We are searching for any other book in place of that.
It is not a book. It's a compilation of orders by the Supreme Court.
But it is not available even if in Amazon and in other also. We have searched for them.
I have one book. In fact, Rutvik Datta and Bhupendra Yadav have written that. Bhupendra Yadav is for.
We have given the photocopy also, but it is not available
in the market.
Exactly. We have searched for many times.
That's true. You give.
It is Bhupendra Yadav and.
Correct. You give a good contract act by Cheshire, Fifoot and Firmston. One of the finest law of contract which I have read. the counter has been filed.
It is less costly.
It is not that costly. Maybe about 3,000 rupees. Give it to library. The counter has been filed after brooking a delay of about 7 years of issuance of the notice in the matter. Personal. Normatively, it has to be filed within within a period of 30 days. First off. Any explanation is given why counter is being filed belatedly? Perhaps you will not. No explanation appears to have been given for the delay, long delay proved in filing the counter. First off, the government and the Article 12 entities have to conduct themselves as model litigants before the court. First off. Anyway, the counter cannot be rejected merely on the ground that it has been belatedly filed. First, next paragraph. For one more sentence. However, it cannot be unconditionally taken on record, ignoring the long delay, either. First off, next paragraph. In the above circumstances, the counter filed in this case is accepted on record and it would become part of the pleadings in the case, subject to the rider that the which OP has filed the counter? OP number 3, presenting to the Advocates Association Library, High Court Association Library, High Court Association,
High Court Association Library.
Association.
This is known as Madhusudan Library.
To Madhusudan, see, right, that how it should be.
Madhusudan Library of Odisha High Court.
Madhusudan Library of Orissa High Court. A famous book, namely Law of Contract, inwards, by Cheshire, Fifoot, Fifoot, and Farmston, within 2 weeks.
2 weeks.
2 weeks. 2 weeks.
And if it will not be available, then online. We have tried. I have conscious because that Godavaram also I am conscious. Since last 1 month we are searching that book. No, we undertake to file this
Understand.
matter. Taken.
Understand. If the book is not available, if that book is not available, then
Theory of Justice.
Huh?
Theory of Justice by John
very
Rawls.
small book. Theory of Justice by John Rawls is a very small book. It is.
Both the books, Political Liberalism and Theory of Justice too.
But very small and very cheap also. Indian editions are available.
Good book.
In the alternate, if that book is not available in the market, then in that state, the following 3 books shall be presented. Number 1, A Theory of Justice by John Rawls. Number 2, another one which you say?
Political Liberalism by John Rawls.
Political Liberalism.
That's the extension of
by the same author. Then Idea of Justice, you
Yes,
give
by
that, because it
Amartya
is written in contradistinction to Theory of Justice by Amartya Sen. Idea of Justice by Amartya Sen. Then together it will be, I think, cheaper it will be. A set of 3 books that will follow into this. All right. We'll call this matter after 2 weeks. All right. Then very difficult for me to ensure that the government will abide by this order.
The short point is, though they have appointed, but because of the wrong computation of the marks, which has been subsequently 2 months after it was sorted out, then this order was passed, which has been assembled by my learned friend. Let it be on merit, my lord.
Anyway, I will call this matter after 2 weeks. Wait, I have to ensure the books reach the library. Otherwise, they may not reach at all.
No, my lord. It is not that way.
So many years it has wasted time here. But 2 more weeks will waste, no problem.
Item 28.
Call this matter on 21st?
My lord.
21st. Okay.
Item 28.
25.
Yes.
May I please, Your Lordship?
Yes, sir.
The petitioner is here for regulation of his services, my lord. He was initially appointed in the year 2000, my lord.
Any objection is filed?
Yes, my lord.
Yes.
Objection has been filed. Your Lordship may see.
They have rejected the regularization.
Yes.
When you joined the...
My lord, initially I have joined in the year 2000 as per Annex 2. Lordship may see page 51 of my brief, my lord.
Page 51.
51.
What is this in pursuit of letter dated? Mrs. shall be engaged as part-time teacher from the date of taking classes till the end of 19... That was for 1 academic year.
Yes, my lord. I continued thereafter, my lord.
When did you join? Did you join there?
Yes, my lord. Immediately the next date, my lord. On that day, I joined, my lord. And I wrote
on 17/1/2000.
He joined on same day?
17/1, my lord.
17/1/2000, Annex 3, page 33.
Annex 3. Who all joined?
I have joined, my lord.
This is dated?
22 to the
26 July 2002. No, where is your first one?
In the first writ application, they are another writ application. 28782. The connected writ application. In that, my lord, I have given, my lord.
It's also here today?
Yes.
Or disposed of?
No. That is there. Because I filed this writ application, why I am telling, my lord. That I have challenged, my lord, during my there was 2 writ applications pending. This was disposed of to absorb me, my lord. They filed a writ appeal, my lord. In the writ appeal, my lord, this honorable court said that since no post has been created for that since long, he approached the government, but you cannot terminate him and by another contractual employee. So, my lord, they filed the counter, they said that by a resolution of the Dean's committee, we have decided not to, my lord, create a post. For that, I have filed this writ application challenging that resolution and the decision of the government, this on the board of management of the college, my lord.
Slowly, one by one. You have to stop. You have to give me pause after one sentence.
Sorry.
Because I have to assess its ramifications, truthfulness, possibility.
My lord.
In fact, Osho, Bhagwan Rajneesh, says, pause is very important part of speech.
I understand.
Because it gives an opportunity to the addressee to absorb what is being told to him. That right of the addressee should not be violated. Okay. So you joined as a part-time teacher.
Part-time teacher, man. Part-time lecturer, man.
Part-time lecturer. Teacher or lecturer?
Teacher.
Any difference between these two?
No, the advertisement may be same. Annex 2.
Advertisement says what?
Second 2023 first আসছে না সেটা ধরুন 23 first আসছে
teacher with the effect from
17/1/2000 I joined in 17/1/2000. The advertisement is under Annex 1.
One thing. Advertisement. Dated,
my lord, 14th May 1999.
14
May 1999.
Annex 1.
Annexure 1, my lord.
Page 50.
And followed by notice.
Yes, followed by notice that confirms my appointment.
Followed by notice dated.
Notice date 12/1/2000, my lord.
Annexure A2.
2, my lord. 2, my lord.
Page 50.
Annexure 2.
My lord.
Then you had approached writ court.
No. Thereafter, I approached the authority that since I have continuing and there is a need of a teacher, make me regular teacher. I may be allowed to work as a regular teacher. And under Annexure 4, my lord.
Where is the representation?
My lord, Annexure 3, my lord.
3.
3, my lord.
Go to 3.
And page 52, my lord.
This is College of Fisheries.
Yes, College of Fisheries, my lord, under the, my lord, Odisha University of Agriculture, my lord.
Technology.
Agriculture and Technology. And the second paragraph, at present, I came to know that the OEOT authorities is going to consider the part-time lecturers as full-time lecturers. I therefore submit the herewith the details of biodata along with all the certificates and mark sheet, etc. Favor of your kind concerns for taking necessary steps at your end.
No, kindly see that. In the first paragraph, you have mentioned 5 persons.
5 subjects, my lord. I am
These are
teaching.
subjects.
Yes.
In which you are teaching.
Yeah, I was teaching, man.
What was your drawals?
My subject was statistics.
No, money, your wages being paid.
That time as consolidated pay of 2,000 I joined, my lord.
2000. What is your qualification?
My qualification is, my lord, MSc, my lord.
MSc in statistics.
MSc in statistics, my lord.
Statistics.
My lord.
But you will teach fisheries.
But there is a subject in, my lord.
Statistics only.
Yes. The subject of statistics with computer knowledge, there's a subject, my lord, there.
Fisheries statistics.
Yes, my lord.
That was the prescribed qualification.
Yes, my lord.
Your MSc statistics.
My lord.
At that time, that was.
At that time, that was the qualification.
My lord.
Any interview or selection process?
Yes, my lord. I went through that and thereafter I was selected, my lord.
Is it true, brother?
Yes, sir.
Selection process was it there?
Yes.
As per Annexure 2, notice was given the engagement notice. His name has been reflected.
That's all right. But any selection process was undertaken?
Yes, my lord. And under Annexure 1 was the advertisement. As per the advertisement, I went through a selection process. Thereafter the
interview.
Yes.
Interview.
Yes, my lord.
Who is the appointing authority?
My lord, the appointing authority is the director of the fisheries.
Under which rule?
Under the, my lord, that statute 66 sets, they have a act on, and there is a OEOT statute 66, 1966.
Show that.
My lord. It is.
Were you brought on a full-time level?
No, I have not been till date. I have not been, my lord. It's 25
How many
years.
hours you are teaching?
My lord, I am teaching in like a full-time teacher, my lord, full-time lecturer, my lord. But what they have done, my lord, after my lord, I have come to this court, my lord, they are paying class-wise, my lord. And now they have reduced my classes because I approached this honorable court. I have also filed a miscase in another writ application.
No.
Yes, my lord. That I have given the details, my lord. And now what has happened, my lord? They have made a resolution not to regularize me.
No, not to create the post.
No, they have created the post, but not in statistics. What they have done tactfully, my lord.
One class is required.
Just a minute, man.
6 class per week.
Just a minute. they have created a post in statistics with economics, so that and the qualification has been changed. And they have, in fact, my lord, while I was approaching this honorable court, they have filed an affidavit. They have already given to the government. I have managed that later also. Their counter affidavit. They will also kindly have a glance to that.
Saying that
They have requested the government to create a post, my lord. That I am showing you also.
who creates the post?
But the government will create the post.
Which law?
My lord, as per their statute, my lord.
Show that.
My lord. There's a new amendment is that they have changed. I have, as per the old address, my old I have quoted. The 99.
What
They have,
you have quoted in the petition?
yes, I have quoted in the petition. There is some changes in the new. I have got the new now.
Old is where is that? Which page you have quoted?
I have madam. The board of management is the authority, and there is an academic council, and
Which page you have quoted?
my lord, page 38 I have quoted.
Yes, 38. Go to 38.
Yes, section 34 of the OAT Act. The first statute, with regard to matters specified in clause A to K, the 34 shall be made by the government after being previously published in the Gazette for consideration of the object, if any, and received from the
No,
public.
it only says how to make the statutes, etc., governor's assent, etc. That's all.
Yes, my lord.
Where are the statutes?
The statute is here, my lord.
Who is the appointing authority?
The director of the OUAT, my lord.
Which statute says that?
The power of the duties of the board of the faculties.
In the earlier round of litigation, brother, I'm asking you.
Yes, sir.
Did you take up the contention that he is not qualified, or that he did not undergo interview, or that his appointment is by incompetent authority, or that his services are
My
unsatisfactory?
lord, initially he had filed a writ petition. That was, in that case, Honorable Court directed to consider his case.
Yeah.
And then thereafter we have challenged that case in writ appeal. Writ appeal, that order has been already modified.
Modified, saying that he will continue, but no direction to absorb him.
No,
Yes,
system-
there is a direction to create a post, my lord.
Till
Great
40
post also, that was
Yes.
set aside.
No, till
No, that was not set aside.
That was not set aside.
That was not set aside. What they did, my
he
lord.
will continue
Right?
till superannuation. He will not disengage by another appointment.
Another appointment.
Yes, ma'am. That was the order.
But the direction to create the post,
Yes, madam.
that is there. Which is the page of the order?
My lord, that page 99, my lord.
Go to 99.
You'll also may come to page 98 first, my lord.
98.
Yes, ma'am. 90. Page 90.
Last paragraph, my lord.
Page 98 में kind से.
Last paragraph.
Last paragraph.
Be
Page 90.
that it as it may, since the respondent number 1 has served more than 17 years in the post part-time lecturer in statistics, we are of the opinion that his service should not be terminated to be filled up by another part-time lecturer. So we paused the notification of 2008 because there is no vacancy for the same post. OUAT is directed to stopgap arrangement and fulfill the directed to consult with the government to create appropriate post, not to resort to part-time appointment and contractual appointment. However, the respondent 1 shall continue in his post as long as he desires or he attains age of superannuation. In case future substitute suitable post is created, therein can be absorbed. In case his case shall be considered as per statute 49 of the OUAT statute 1966.
So till that we have not disengaged. His condition.
Now you'll also may come to next page, my lord. 101, my lord.
How government has power to create the post?
Yes, they will.
University.
Yes, my lord. They will.
Which is that section?
That my lord, because of the power.
Who creates the posts, brother?
The
Board of Management.
In your
Board of Management will suggest for creation of post, the government.
Which is the statute?
My lord.
Board of Management.
Show that, which statute?
Power of Board of Management is section statute 14. In addition to the powers and functions.
Powers of Board of Management. In addition to the powers of function mentioned in section
there will be many powers. Read which is the relatable.
15. Statute 15. Power
Do you have
due
a
to
copy
the...
of that book?
Yes, madam.
Please share a book with me. Present one book to our library, High Court library, so that we will have. Otherwise, we will not be having those
Statute
books.
and I am sorry.
Give that.
Page 23 statute.
Statute?
Statute.
That's
Page 23.
statute making power.
Yes,
Let
ma'am.
us go there. Powers of the board of management.
Yes, madam. Powers
That
of
is
Board.
called, that is like Senate.
Yes, madam.
Page.
Powers and page 23. Chapter 3.
Power to create post is where?
Yes, by statute 15, clause 2, to appoint such committee as are required by the act or the statutes as such other committee either standing or ad hoc as it deems.
Which one?
Clause 2, 15 clause 2.
To appoint such committee as are required by the act or statute and such other committee.
And such other committee.
No, it is for appointment of committee,
Yes, ma'am.
not the creation of post.
Thereafter, this 3, to determine the recommendation of the dean's faculties, the establishment, amalgamation, division of abolition of faculties or department. That is the duties. Powers and duties of the Academic Council of the Board of Management.
Where is power to make appointments and power to create posts?
This is chapter 5. It deals in the chapter 5, my lord. Page 31, my lord.
The teachers of the unit shall be classified into 3 categories as follows: persons appointed for the purpose of imparting education, persons conducting and guiding research, persons declared by the statute as teachers. The post held by teachers belong to each category alone shall be designed, designated as
Classification of teachers.
Then 20, my lord. Notwithstanding anything in statute 3, any post under the university may, if the board so decides, be filled up by deputation of an officer in service of the government for such terms and conditions as a teacher, officer, any other employee may be requested to government to be deputed on the government on such terms and conditions as may be determined.
The creation of post.
Board of Management
Creates the cadre. Where is that board's power?
Board of Management is competent to.
Where is that? It appears to be hastily drafted statute.
In the old one, my lord, it was directly in the old one. I'll produce that before Lordship. If your Lordship wants that, I do not have found, my lord. That the old one, which it has been amended in 99. Prior to that, where it was specific direction was there by the Board of Management, the Academic Council will approve and the Board of Management will decide.
Decide what?
the section 16, this clause 16 was the power of the Board of Management, and the clause 18 was the power of the Board of the Academic Council. They will recommend and the Board of Management will approve, and then it will send to the government. And clause 34 was there, that the government will approve those things. That has been not been in this amendment. Those are not there.
Come to part 3, chapter 11. Let us see. Come to 31.
Yes,
The
ma'am.
service consists of such classes as may be classified by the board. Perhaps that will give power to the board to create posts. It will come after reading the whole of the statute book, assist the court.
Lords may give me a short adjournment, I will see. Because this new statute and the old statute were there, that differs, my lord.
A very small act. Small act with too many mistakes. Any statute for appointment?
There's an appointment for contract, there's a statute 34. But
to look into and come back. If no, but assistance, quality assistance is not forthcoming.
No, I am conscious of that, my lord. Because of this new statute, the old statute, my lord, I have quoted those provisions. But
you call this matter
next week any day. Tuesday, Wednesday, any day. As per convenience.
On 12th, okay, 12 we have already posted many matters.
13th?
On 13th.
Oblige. Much oblige. The pura statute change for
the chart of date.
Month. I have prepared a date chart for your lordship. I'll give that.
That helps us. And who has power to create posts?
Yes.
What is the role of the government? That you have to state.
Yes.
Why court proceeded on the assumption that the power to create post is not with the university at all. The division bench underwent has structured the judgment on that premises, and everywhere it said petitioner shall be continued in the post. There are 7 sentences like that in that judgment. That means there is a post.
Item 29.
If there is a post, where is the difficulty in absorption? Where is the requirement of creating
There is
the
no
post?
post. There is no post.
But throughout the judgment proceeds that petitioner shall be continued in the post in which he is working. 7 sentences are there. I just counted them.
So no vacancy was there at that time.
In fact, those
In
are the
that post-
requirement.
post-
RJ Lawson knows that liance judgment, the post will not fall from heaven. When there is requirement for the post, I have
to create.
imparted my service since my last 25 years.
No, in the meantime-
and the students are reading that it is their fault they are not created the post. When that
You show the power to create the
I'll show that.
In the manual, government has approved the sanctioned the post one total. I have already stated in my affidavit.
government has sanctioned the post now.
Yes, ma'am.
Then you
What-
absorb him.
Total 184.
If that is so,
Yes, ma'am.
then you have to absorb him in that post.
No, sir, that is on direct
Qualification,
recruitment. That will decide on direct recruitment.
Direct recruitment.
Yes, ma'am.
What should happen to a person who is serving you since last 20 years,
25 years, man.
25 years?
In that college also, post has been 24 post has been created.
If 24 posts are created,
Yes.
why can't you accommodate him in one? There is a direction by the division bench. When posts are created, he should be accommodated there. Kindly read the last portion of the division bench order.
Actually, his qualification is MSc in statistics.
Correct.
Our
But you have
requirement-
added economics to that.
Our requirement is bachelor in fishery science or master in fishery
Now,
science.
Why did you have his services in your university? You should have dispensed with service, saying that you are not required at all.
That
These are not qualification, present qualification. Only statistics.
Only statistics.
Yes. Only 6 classes is required for.
Only statistics.
One
coupled
per
with
day.
no, not like that. Only statistics coupled with 25 years experience. You mean to say experience has no role to play in life?
The present requirement 1 class is per day.
Well, if that is one post, then you have to accommodate him in that.
That's why they are continue as part-time teacher.
In that post.
Yes, ma'am.
Then you have to absorb it.
Actually, no, there is no qualification. He has no qualification. Fishery science he has no qualification. Only statistics, MSc in statistics.
Now, for the fresh recruitment, you can insist upon all that. But for the person, because the direction is, whenever in future post is created, he should be absorbed.
Yes, ma'am.
There is such a direction.
Yes, ma'am.
and their statute 49 also says that.
The 49 also omitted. Statute 49.
49 omitted.
Oh, yes, 49, Michael C.
Omitted after the judgment or before
Yes,
the
after the
judgment?
In
judgment.
times,
After the judgment, they have requested the government to omit, but that has not been omitted till now.
and
They have requested the government to omit
in
that.
my affidavit that has been annexed, page 26.
Not yet omitted.
Not yet omitted.
He says it is not yet omitted.
The notification copy is enclosed.
Where is that?
Page 26, my affidavit. Additional affidavit. Annexer N/4.
Then it has, where is annexer?
Annexer N/4, my additional affidavit, which was filed in WPC 2878 of 22.
That is with effect from which day?
6 to 25. February.
6 to 25.
Yes, ma'am.
But before that, the judgment was given before that.
Yes, ma'am. 19.
Yes. You abide by that judgment. You cannot silence the judgment of the court. We'll allow this petition then. Because last 25 years he has been serving.
Yes, ma'am.
He has added experience. There is one famous statement by Oliver Wendell Holmes, a great judge of US Supreme Court. He said, the life of law is not logic, but experience. Experience has got its own role to play in man's life. 25 years of teaching experience. Oliver Wendell Holmes' famous book, Common Law. He says that. Similarly, that way, may not be much applicable to this case. But experience, I'm only saying the experience which man gains in the process of life is valuable. It's called in Sanskrit pramana. Anubhava, pramana, anumana. This is pramana. Experience is pramana because it arises out of experience. The lessons are drawn, competence is gained. That is the reason the court said, don't leave him. Continue him till he attains the age of superannuation. That's the direction.
Till that we have not decided that for the order of the High Court.
I know you have to
We
obey.
will continue.
You have to be seated. Be seated. Whenever I need your assistance, just assist sitting only. Need not stand up. Petitioner who holds MSc in statistics was selected as a part-time teacher with effect from 17 January 2000, pursuant to his application against the advertisement dated 14/5/1999 at Annexure A1, followed by notice dated 12 January 1999. How can be? 12/1/2000. Is it 12/1/2000, brothers? You should be attentive to the court dictation, not chit-chatting in the court.
No, I was saying that
As a chit-chat, I never did it in my classroom.
I'm sorry.
Yeah. Is it 12/1/99 A2?
Yes, my lord.
12/1/18. How?
12/1/2000.
12/1/2000. That Annexure A2. In the first term. She has, please be seated. Be attentive. Avadhana is a virtue by which one gets knowledge, giving concentration to what is being said, what is being told, giving full concentration. That art should be developed. Yes. He had knocked at the doors of this court earlier in WP number
28782. But that earlier state application.
petition
14252 of 2008.
14252
2008, my lord.
2008, wherein a coordinate bench directed absorption of your service. Absorption of service. To consider absorption of his service
As per statute 49.
under the then statute 49 of what statute it is?
UT statute 1966.
OUT statute 1966. First term. The university having challenged the said order in writ appeal number
400 of 2017, madam.
Comma, a division bench of this court partly allowed the appeal and removed the direction for creation of the post and absorption, specifically stating that petitioner should be continued in the service till his superannuation.
As he deserts, as long as he
Or otherwise he quits. First one. Next paragraph.
And said also said that if the future post is created, it has to be absorbed.
A direction was also added to the effect that the case of the petitioner shall be considered for absorption if and when posts are created.
As per statute 49.
In terms of the said statute. First one. Next paragraph. When the posts were created?
In 21.
now in my affidavit, As stated in my page 19. Page 19, annexer K/4.
We are asking whether the
11/4/2023, my lord.
This is government letter.
11/4/2023, my lord.
11/4/23.
My lord.
You filed the writ petition on which date?
But I filed the writ application, my lord. This writ application, my lord. The earlier writ application, my lord, on 22, my lord.
No, not that. This the present petition is filed on which date?
First writ application was filed on, my lord, the 22 application. 28/10/22 first writ application was filed.
The second one?
The second one was filed on, my lord.
5/1/24.
23, my lord.
5/1/23.
15/12/24, my lord. 23, my lord.
15/12/2023. Next paragraph. The university created certain posts. Why the notification dated 11/4/2023?
Government letter may be kindly seen annex page 19, annexer K/4. That is government letter. Government has regarding creation of post in College of Agriculture of Patna College of Fishery, Rangelunda College of Community Science. Total 184 numbers of posts were sanctioned.
Followed by
government.
Sanctioned by the government. First stop.
The government sanction was first, my lord.
Preceded by sanctioned by the government. Why letter dated?
19/12/2022.
19/12/2022. Correct?
My lord.
Conferred by Finance Department.
First stop. It is told at the bar that this sanctioning was after securing the approval of the Finance Department of the government. First stop. Did you give representation of the creation of the posts?
Yes, ma'am.
Posts are created now, observing.
No, till now I have not given. Since this is pending, I have not given.
Despite creation of posts, the request of the petitioner for absorption having not been considered in terms of the direction of the division bench in the writ appeal filed by the university itself, petitioner has filed this petition with the following prayers. Prayer column. Next paragraph. After service of notice, the respondent university having entered appearance through its panel counsel has filed the counter resisting the petition, essentially contending that although posts are created, the petitioner cannot be absorbed therein in as much as the prescribed qualification happens to be MSc statistics with economics.
Prescribed qualification as on page 23, annexer L/4.
What is that?
Yeah, in my affidavit I have enclosed that.
I am asking that. What is that qualification?
A minimum second class bachelor's degree in the concerned subject with at least 55% mark equivalent to OGPA. Minimum second class master degree in concerned subject with at least 55% mark equivalent to OGPA.
He has that.
The candidate must have cleared a national eligibility test with one publication of NAS rated journal.
NET.
Yes, ma'am.
Coupled, what you say?
Next, for candidates having PhD degree in concerned subject with course work as prescribed in the UGC regulation 2009.
Statistics. Sans NET. NET. First stop. That's the only ground. He does not have requisite qualification.
The prescribed qualification has been annexed.
Which is that?
Page 23 L/4
Of
in my additional affidavit.
into bracket, just you write. See page
30th October
23 of additional affidavit.
Filing the other writ application, my lord.
Eh?
Filing the other writ application, the first writ application.
An additional affidavit.
Appeals or petition? Where are you saying?
The first writ application that is connected, that is 28782. In that they are filed.
How many cases are here?
2 cases are there.
Why 2 cases?
The first case, my lord, I have challenged that since they have published some notification for absorbing again part-time teachers, my lord.
Also. Next paragraph. Having heard the learned counsel for the parties and having perused the petition papers, this court is inclined to grant indulgence in the matter as under and for the following reasons. First off, kindly be seated. And you can answer by sitting only. You are all honorable members of the bar. Yes. A. The respondent university is established. We'll give the books, court officer, book master, do that also.
That is the act, that is it.
Respondent university is established under the provisions of Orissa what is the name of the act?
Orissa University of Agriculture and Technology.
Technology Act 1965.
The Orissa University of Agricultural and no, these are statutes.
The act is the small one of the act.
The Orissa University of Agriculture and Technology Act 1965. First off, the university has promulgated statutes, a set of statutes in exercise of power delegated by the 1965 Act. Under the provisions of the said Act, the board can create posts on the recommendation of the academic council, however, subject to sanction by the government. First, accordingly, a set of posts have been created wide notification dated 11/4/2023 and certain educational qualifications are prescribed as well. First off, the vehement submission of learned counsel for the university that although posts are created, petitioner cannot be absorbed in them for want of educational qualification is a bit difficult to countenance. First off, true it is that It is the prerogative of the employer to create posts and to prescribe requisite qualification therefore. First off. However, when it comes to absorbing already long-serving employees, sans any complaint whatsoever, such a plea cannot be countenanced to prevent absorption. First off, an argument to the contrary would be unjust and arbitrary, more particularly when the prescription of the requisite qualifications is of recent origin, whereas the petitioner has been serving the university, as already mentioned above, since the last quarter century. First off, 25 years or the substantial part of human life. And at least as a concession to the shortness of life, relaxation ought to have been granted by the university regarding head to the sweat and blood which it extracted from the petitioner all these years. First off, it hardly needs to be stated that experience has its own advantage, especially in the realm of teaching. First off, much of meaning of life is experience itself, to say the least. First off, this next paragraph. The petitioner's counsel is right in submitting that in the earlier round of litigation, the university had preferred a challenge in writ appeal number
400 of 2017.
400 of 2017, wherein the division bench modifying the order of the learned single judge in petitioner's WP number
17. 1424252 of 2008. 14252 of 2008.
254. Slowly, he has to write.
14252 of 2008.
8. What you have written? No, sentence.
Wherein the beginner is modifying the order of the order
disposed of on held that petitioner should be continued in the service of the university, and that whenever posts are created, he should be considered for absorption therein. First off, it was only for the want of regular posts, the division bench had interfered with the order of the learned single judge. Otherwise, arguably, the university had no case in writ appeal. And eventually, the order of the learned single judge would have attained confirmation at the hands of the division bench, as rightly contended by counsel for the petitioner. A model employer like the university, which is held to be a state under Article 12 of the Constitution in Ujjambai versus State of MP, which is that UP? MP. You can see that judgment in Google. Sit down and see the Google. Which is that judgment? Ujjambai versus
Mumbai versus State of
Uttar UP
1962 AIR 1621.
AR 1962 SC 1621, has to conduct itself as a model employer. And its policy should not be hire and fire of laissez-faire era. First of all, whatever additional qualification that are prescribed only in April 2023, need not come in the way of considering petitioner's case for absorption when he has a rich experience of a quarter century. First of all, which is that judgment where Supreme Court said experience itself is a qualification. Take out from Google.
91 Supreme Court.
91 Supreme Court.
Reasonable experience can well substitute the educational qualification.
Correct. The apex court in so and so observed that the long experience itself can constitute a qualification. First of all. Next paragraph. In public employment, though the service begins with the contract, it attains status. Wide Tulsi Ram Patel versus Union of India. First of all, a person having post-graduation and experience of 25 years of teaching is an asset to the university. And therefore, he cannot be allowed to stagnate with the same status throughout. First of all, an argument to the contrary would dampen the spirit of teachers, which in turn will affect the interest of community of the taught, and therefore cannot be countenanced. Next paragraph. In the above circumstances, this petition succeeds. Any quashment you have sought for? Quashing of orders, nothing. A writ of mandamus issues to the university to positively consider case of the petitioner for absorption in an appropriate post by relaxing freshly prescribed qualifications and treating his experience itself as the qualification, within a period of 8 weeks. 8 weeks. First off, delay shall be viewed very seriously. At the next level of legal battle, if at all petitioner is driven to. First off, no course. Leave these things with the court. One set you can give.
Yes, sir.
That judgment, I need experience itself is qualification.
I'll do that.
That give that judgment. All right? Okay.
Just one more thing to add, my lord.
What the patients are.
Just one more thing to add, my lord. In the meantime, he has also acquired the doctorate degree in statistics, PhD in statistics.
You have acquired a PhD also?
Yes.
One more sentence we should add. We are told at the bar that the petitioner has acquired a doctoral degree in statistics. When?
2012, my lord.
In 2000, way back in 2012 itself. That you can add that.
That's the blame.
Little modification of the linguistic structure will undergo when I finalize frame the judgment. Okay? The order remains intact. Okay.
Item 29.
May I please, Your Lordship? Because this is the second round of litigation. This petitioner was before this Honorable Court seeking a direction to the opposite parties, 3 and 4, for regularization of her service. She has been working as a typist, then data entry operator, and then junior assistant on Utkal University for the last 28 years.
28 years.
28 years.
What is the qualification?
She is a postgraduate in Orissa. That apart, she has passed PGDCA in computers and
PG diploma? Diploma course, PGDC.
Yes.
In
Para 14, I have stated the qualification. She is a postgraduate in Orissa with a technical qualification of stenography and typewriting. Besides this, she is also possessed of the qualification of PGDCA and is thus fully qualified, eligible for regularization of a service in the post of a typist, data entry operator, assistant, junior assistant, as the case may be, in view of a possession of a qualification for above such post.
When she joined the service?
Millard, she joined the post on 8/8/97, and since then, 8/8/97, that is also admitted by the opposite party in the.
All right. I'm asking questions.
Yes.
Answer the question
Yes,
in a short way,
yes,
so that it becomes easy to me.
Yes, Mila.
And will not create doubt on your version. Joined service of university on 8/8/97.
87.
As
a typist.
After selection?
No.
Without selection?
Without selection.
Daily wage basis.
Daily wage basis, keeping in view the requirement of university, she was selected and engaged in that post.
Selected?
She was, yes.
Do you understand what is meant by selection in service law?
Not by any procedure. However, taking into consideration her qualification possessed, she was appointed and engaged as a typist. And while working in the said post, she was engaged as a data entry operator. In subsequent period, she has been working in the post of a junior assistant.
As she joined as typist.
Initially joined as typist.
Was there a vacancy in any post vacancy?
Yes.
What have you stated in the petition?
In my read petition, I have stated that she has been working against
sanction post.
Have they denied it?
Well, it's
Have you denied?
in fact, my instruction says counter has not been filed, but the instruction
You
is
need not file counter at all. Why do you? We'll argue.
my instruction is that actually this petitioner had never undergone any selection process.
But he, 1997 here.
Yes, ma'am. So I am conscious of that fact. And thereafter the instruction is that she was appointed in a post under the DDC, Directorate of Distant Education, which happens to be an independent wing under the university, but the registrar is not empowered for appointment in the DDC. It is done by the director, and the director, she has been appointed by the director. And our
Director is the competent authority.
The competent authority to engage or to take the hands as and when necessary.
But you have taken the hand for 25 years. Yes, 30?
28.
28 years.
My lords. And
27 years.
And here, what I would like to submit on the basis of instruction is, the registrar is no way the appointing authority in case of the petitioner.
But he represents the university.
My lords, I do agree, because the registrar happens to be the
CEO of the university.
My lords, under Section 4 of the Act,
Yes.
he can sue or be sued. So there's no dispute about that. But in this particular case, what I am trying to place before your lordship, that certain cases, to give your lordship a background of the regularization cases, there are three categories actually. The persons who have already been engaged for years, like this of the petitioner, they have come for regularization. And another category who have already been regularized in Group D posts whenever available, but they have come before your lordship to regularize them from the initial date of engagement, which was never there. And the third category is who are still working and have come for the regulation. And for your lordship's information, your lordship has kept a batch of cases for hearing in 2 sets in the first week of
No, but this set is not there.
No, this is not there. That is not there.
Therefore, we'll decide it today.
Today
is a very good day.
As your lordship pleases. I have nothing to say. But here, in this particular case, my instruction is, and I would like to place on that is, that since he was never appointed or never been given an appointment letter by the registrar, and the university has a separate set of rules, 91 recruitment rules, by which the non-teaching staffs are appointed by the registrar. So his case has been negatived under Annexure 21,
Rejected.
which is in challenge.
Where is that?
Your lordship may kindly turn to page
84. No, 84.
Go to 84.
Page 84, Annexure 21. That is in challenge before your lordship. If your lordship allows me, I'll please.
But you say registrar is the appointing authority.
My lords, under the 91 recruitment rules, my lords, there's a separate set of rules.
What action you took against the person who appointed her in contravention of these rules?
No, as regards action, I'll have to take specific instruction. But since the director, since that's an independent body, and the director hasn't
went by independent body.
Independent body in the sense it's a wing of the university, but the director is empowered to, as I stated before your lordship just now, that to engage persons as and when required. So
where is that power?
That power of
university, same university which we passed the order.
No,
different university.
This is Utkal University.
University.
That 91 rules is not with me at present.
In the pocket of the Vice Chancellor?
No, not exactly that way, because what I was trying to place before your lordship is
how panel council should be.
No, that
you are selected out of so many people because of your competence.
Definitely, my lords. Definitely.
But if you come to the court without the rules, and your university people will be seeing online that I am saying this to you.
Exactly. So I do bow down to what your lordship says. There's a drawback at my level today. But what I had initially thought of presenting before Lordship is, since these matters are being heard in batch, so it should be placed that way. That is why
No, there is no other batch. This is the only one case, actually. No, brother, we are asking you. I have seen you arguing very well in other matters. Therefore, I am asking the 27 years of service, if you permit her to work, and after 27 years, one fine day, you will tell her, no, your appointment is bad. It is like saying a husband telling his wife that the first child, which is 27 years old, is doubtful.
in the lighter way, if I'm to submit before your
You
Lordship,
should treat your employees as children.
that
You should never treat them as illegitimate children of yourselves.
not only that, my lord, if I'm allowed to submit off record, then we cannot do without them. At this point of time, we cannot do without them. But that is off record. That's not need not be recorded as my submission. But
We'll allow this petition.
because question is, once we talk of a humanitarian ground,
Correct.
that's true. That's true. What your Lordship says, because
So law. There is one famous book by Julius Stone, Human Law, Human Justice. Some youngsters can take out that book. Human Law, Human Justice. Julius Stone was a great thinker. His law and legal reasoning, his jurisprudence. What kind of books he has written? Without all laws address human beings.
definitely.
Even the prevention of cruelty to animals, they address human beings only, not the animals.
Even law is made as per the need of the society.
To mitigate the hardship of human
That's true.
beings.
That's true.
That's the object of law.
As a human being, I have my own. But as a counsel for the university, I have my reservations.
I understand that one. But this is a case for 27 years. You cannot say that no, you are my illegitimate child and therefore I will not give you any property. That's too much. Every passage of time, in one judgment we have held in which Mr. Mohanty argued, whatever illegality in the order of appointment gradually diminishes by passage of time. By efflux, you are right, by efflux of time. That word we have used. You can't say, no, what Alexander did is illegal.
No, that exactly what your Lordship said in the earlier case also.
Yes.
Experience sharpens.
Correct.
Experience sharpens. Definitely. I'll bow down to that because me at the bar when I joined in 90 and now that experience sharpens. Definitely.
Experience.
That I can have no second opinion about that.
Then we'll allow this matter.
But what I was trying to place humbly before your Lordship, since these DGC employees, there are certain other cases in batch as regards these DGC employees. So if your Lordship can consider that together, I would be.
When that is posted?
That is posted to first week of September.
Do you
and
have
I'll furnish the numbers.
And kindly do not mistake when I say I generally show my red eyes to those who come without preparation.
Definitely, but
That's my nature.
definitely, Badals.
I am not sent
No,
here.
even then we
the
know-
hearts of the bar members.
No,
I am
exactly.
sent here to work for the state,
My lords.
work for these people.
No, we don't do justice also to the clients, not to the courts when we are not prepared. Today, I do bow down and I am shameful about the
Anyway,
fact.
you have don't say that because sometimes it happens. We understand because I have seen you arguing very well in other matters.
Yes,
That one. Kindly do not use shameful, etc. You are also senior and respectable member. I will have this matter in the first week as he rightly submitted. So honestly, he said.
Oh, yes, your lordship, please.
That one. On that day, we will consider this. In the meanwhile, get copy of that judgment from your friend Mr. Mohanty. a division bench judgment. Just get it. But I have seen you arguing very well in matters and very fairly also. So let us.
There is an interim order in that maybe made to continue.
Interim order.
To continue, I have nothing to say.
Heard.
I ordered.
Council appearing for the parties. Interim order to continue till next date of hearing. Call this matter. Really, in fact, I appreciated before two of my brothers about your performance. I should tell that also.
And in the meantime also, I'll put that counter on record.
That I don't know. That risk you will have. You consult morally and you will advise.
No, if your lordships only permit me to have the risk of donating books.
That's good thing. Do it. Let us see. Call this matter in the first week of September 2025. All right. I kindly do not mistake my words. My only concern is there should be upgradation of the law. And most of you should become the silk wearers, the senior advocates.
Definitely.
Before I demit office on retirement, I will be extremely happy because you are all doing so well. You are really. I am not just praising you. I am not in the habit of praising at all.
No one.
Many times.
Persons will only put on his face also.
I praise whenever there is praiseworthiness, and I do not praise when the words are not. I don't appease people. I do not appease. It's not in my nature. Whoever performs well, I give encomia. Whoever underperforms, I tell him you are an underperformer. Because there is no other case than to improve the bar. Bar has to be improved. And Oscar Wilde said, there is scope for improvement even in heaven.
Balance.
Heaven also can be improved. Why not our bar? And why not bench chance? If you come with preparation, we also go home making value addition. And we tell our
no, once we are prepared also, we have a different kind of feeling.
It gives a standing.
Was it positive vibe?
It gives a
because
standing.
once we are not prepared, we come with a very low mind.
That's true. All right, you come out with your short objections on the next day of the.
No, in fact, lacuna in addressing your lordship is on the personal front of mine. Bit tragic. I've lost my spouse on 29th of May.
Very bad. Very bad. Good. You are an extremely good lawyer. Death comes to everybody. And we believe in reincarnation. Therefore, and I feel very bad after hearing this. The spouse is part of our body and soul. I understand. After I read the Death and After by Justice Krishna Iyer, he was so much attached to wife. He was an agnostic, non-believer. And he became so much religious, spiritual. Small book it is. He wanted to see his wife who had gone with the wind. So he consulted the H.Y. Sharda Prasad, the advisor to Prime Minister, saying, is there any means to see and spend time with the deceased spouse? Sharda Prasad referred to R.K. Narayan. And R.K. Narayan, the school teacher or the school master, he suggested something. Very mesmerizing writings they are, where the deceased wife comes with Jasmine and spends time with his spouse and goes. That experience, in fact, when I say this after reading that, even my eyes, after hearing you, my eyes have become dampened now. But these things are there. To whom the death has spared, death spares none, except the 7 persons, that including Ashwatthama.
Under the Hindu
Shastras, except those 7 persons. We are all subject to the mortality. There is a famous song, a Hindi song, "Sau saal like pana honge," like this it is in Hindi. My Hindi is very weak, so which is that I do not know. Very famous song it is, which I used to hear during my student days. But I understand the pang of separation. I feel bad. God bless you. You are one of the finest members of the bar, because I have heard it in other matters. So fair and so flowery in language, so effective in your submission. I only share your grief. Thank you so much. Grateful.